right, we are live and recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the April 8th, 2021 sitting of the Massachusetts Appeals Court. I'm Justice Eric Neyman, sitting today with Justice Peter Sachs and Justice Jim Lemire. Our first case today is matter 2019 P1530, Commonwealth versus DEBURGO. And we will hear first from counsel for the appellant, Mr. DEBURGO.
Thank you, Your Honor, and good morning. Andrew Power for defendant John DEBURGO. Now, this case was prosecuted on a theory of joint venture. The Commonwealth argued that David Pellet, DESHAWN Hunt, and my client intimidated Ryan Cook and Timothy Maciel by means of a knife and a gun. Now, at page 26 of the Commonwealth's brief, the Commonwealth states, and I quote, "The crime of intimidation was completed after Pellet swung the knife at Ryan and his family, and they all backed away," end quote. Now, the record shows my client didn't personally use the knife. So the question is, where was the evidence that my client intimidated a witness by means of a knife? Now, under our law of joint venture, Commonwealth versus Zanetti, the Commonwealth was required to prove that my client's knowing participation amounted to use of that knife with Mr. Pellet.
Counsel, is it your position the Commonwealth is saying the intimidation consisted only of swinging the knife?
Yes, the Commonwealth's theory of the case, argued throughout its closing argument and repeated in its brief, was that the intimidation, the element of intimidation, was made out by Mr. Pellet's swinging of the knife at Ryan Cook and Timothy Maciel's family members, and then they're backing away in fear.
Didn't they argue more that it was an ongoing set of facts that started with the parading by the house, the calling out of the rat, and then the escalation to the knife and then the gun?
Yes, but when we're looking at the element of intimidation alone, that's what they said intimidated Ryan Cook and Timothy Maciel. Parading was not intimidating. Rat and snitch, the judge found that to be intimidating, but I will argue that that alone was not intimidating. What was intimidating was the use of the knife and the gun. And there was no evidence of my client's knowing participation in using the knife or the gun, because
he applauded when the knife came out and he advanced alongside Mr. Pello, was it, when Mr. Pello came forward with the knife? So he may not have known about the knife in advance, but he was certainly on board with its being used the way it was.
Yes, and I would argue that that's not sufficient. Now, the prosecutor claimed—
not sufficient for a joint venture to show he knowingly participated with the intent required? Why not?
Because knowing participation requires, first of all, knowledge that he had the knife. So he didn't plan for him to have the knife.
But he saw the knife came out and he started to applaud and step forward with Mr. Pello.
Correct. So assuming for the sake of argument that my client clapped his hands while Mr. Pellet was swinging the knife, that's not enough for intimidation by joint venture for two reasons. First of all, there's nothing intimidating about applause. Mr. Cook and his family weren't backing away from my client, they were backing away from the knife. And the Commonwealth can point to no case where clapping gave rise to joint venture liability for intimidating a witness. The Commonwealth cites Zanetti, but nobody was clapping in Zanetti. Now, the second point is that how do you assist someone in swinging a knife? It's a one-person job, and only one person was doing it here. There was no way for my client to meaningfully participate in using that knife. All you have with my client being there beside Mr. Pellet while he's swinging the knife, or assuming that he was clapping, is association with the perpetrator, presence at the scene, and failure to intervene or to stop him from doing so. And the jury instructions and Zanetti tell us that that is not enough for knowing participation. Now, my client himself had the opportunity to fight Ryan Cook one-on-one. but he backed off. He clearly did not want to participate in a physical altercation with Ryan Cook. So the bottom line is my client didn't do anything but talk and maybe clap his hands once or twice. He had no prior knowledge of the knife. He didn't try to hit anyone, let alone stab at or shoot them. So it should be clear that the jury reached their verdict on the theory of the knife, which had insufficient factual support.
Did the
And that-
defendant seek a bill of particulars in this case? File for bill of particulars?
Not that I'm aware of, no.
So let's take the facts as they are, but instead of clapping, your client, after the knife came out, stood next to Mr. Pellet and said, "I'm supporting you. Let's get these guys," and walked toward them as he did, as was captured on the video. Would that be sufficient to survive a required finding of not guilty?
It depends what Mr. Pellet is doing at the time. I mean, if Mr.
Everything
Pellet
else, let's assume for purposes of the question that all of the other facts of this case are the same.
I think an expression simply verbal, without doing anything to stop anybody, without doing anything to advance the threat of the knife, is not enough. You have the intimidation factor here is the knife. It's swinging the knife. Now, what is he doing to meaningfully participate? I mean, the key adjective here, or adverb, I guess, is meaningfully. So he has to meaningfully participate. He's participating in the sense that he's there, he's present. He's a friend of Pellet, so he's obviously on Pellet's side, and he's not stopping Pellet from going forward. But he's not actually participating in the threat with a knife. And everybody knows they're not backing away from my client. They've already established that my client won't fight. They're backing away from the knife, from the threat of the knife by Mr. Pellet. And my client had absolutely nothing to do with that.
Well,
Now,
the swinging of the knife certainly constitutes the potential crime of an assault with a dangerous weapon. But the intimidation, you're passing out the intimidation as just being involved with the swinging of the knife. It started well before that, as your client led the group down the street, back up the street, stopping, yelling. That's all part. I don't think you can parse out just the swinging of the knife and your client just being present. I mean, his walking, leading the group, yelling, calling them out, doesn't that all go toward his ready, willing, and able to assist in a joint venture with when the knife comes out and he sees the knife and then advances? That's more than just being present when a crime is being committed.
Well, those other things that you're mentioning, though, don't satisfy the element of intimidation. Only the knife. So for intimidation, as this court said in Drumgoole, the essence of intimidation is fear. And as the SJC said in Robinson, arguing is not enough. You know, there has to be proof that my client participated in intimidating Ryan Cook. Now, in previous cases, we see.
So I'm sorry to interrupt, but so if a person walks up to someone who's a witness in a case and says, "You're a rat, we're going to get you," and makes a threatening gesture to them without a weapon, you're saying that by definition, as a matter of law, cannot constitute intimidation of a witness?
I'm not saying by definition as a matter of law. I'm simply saying that you have to look at the facts and you have to look at the standard, which is a reasonable person in the shoes of the witness. So the witness in this case is Ryan Cook, a 21-year-old tough guy looking for a fight. Now, schoolyard insults like rat and snitch, and, you know, even if he said, which he didn't, "We're going to get you," wouldn't intimidate someone in his shoes. A belligerent young man.
Do you have any evidence for the assertion that we use kind of a reasonable tough young man standard versus a reasonable person standard in deciding whether fear of the defendant's actions and words would have been reasonable?
Well, I use the reasonable person standard in the position of the alleged victim, which is based on Commonwealth versus Rivera out of this court, citing Commonwealth versus Cassiano out of this court, in which case the alleged victim was a reasonable police officer. So you have to again use the circumstances of the case. So who are we talking about here? We're talking about
any other case besides a police officer. I mean, any other case that adapts the reasonableness standard to the age, experience, gender, or any other characteristic of the victim, or just uses a generalized reasonable person standard?
I'm using the reasonable police officer standard. Now, obviously, he's not a police officer, but the point is it's a reasonable person in the position of the victim. So in my client's case, the alleged victims here are two young men, very tough young men. One has an illegal 9mm handgun. The other one is out on the street looking for a fight. And you have to ask, would schoolyard insults like rat or snitch intimidate these people? A reasonable person in the position of this person? And the answer is no. And as a matter of fact, they weren't intimidated. Ryan Cook wanted to fight my client as soon as he saw him. Cook, if you look at the video, was pursuing my client and demanding a fight. And what did my client do? He backed off.
The witness intimidation is only complete if the witness is actually intimidated.
No, that's, as you're aware, that's not correct. Intimidation doesn't have to be successful in obstructing justice.
Or actually fearful.
But yes, the essence of intimidation is fear. So the standard is, would it put a reasonable person in the alleged victim's shoes in fear? So who is the alleged victim in this case? That's the first thing you have to ask. There are a number of people out on the street. There's the 17-year-old cousin. There's the 52-year-old truck driver father. There's the 49-year-old caregiver mother. Each of those people are assessed differently. What may intimidate the 49-year-old caregiver mother may not intimidate the 21-year-old street fighting.
And a threat to a family member can be as effective as a threat to the witness, him or herself, can't it?
That is true. And so the threat, when the knife came out, the threat to the family members may have intimidated Timothy Maciel. To that point, none of the language was directed at Timothy Maciel. They were calling Ryan Cook a rat. They were calling Ryan Cook, where's Ryan, calling him a snitch. Nobody was talking about Timothy Maciel. So how did Timothy Maciel get drawn into this? How was intimidation made out with respect to Timothy Maciel? It was made out when the knife came out and the Maciel family members stepped back, prompting Maciel to grab his illegal gun, run outside and start shooting at people. So
may I ask, I don't want to, your time is growing short, and one of your principal arguments in your brief is the Commonwealth's assertedly improper closing argument. Now, there's been an exchange of letters and filings before argument, and the Commonwealth has acknowledged an error in its brief. What is your strongest argument for there being a substantial risk of miscarriage of justice from the assertions in the Commonwealth's closing argument that your client actually called the Hunts and the juvenile to ask them to come over? What critical difference did that bit of argument make to the intimidation charge, and which element of the charge?
Well, first of all, I want to dispute the substantial risk standard because trial counsel objected 3 times to closing, pages 195, 198, and 199, even though he was only required to object once to preserve the issue. But again, this goes to evidence of joint venture intimidation. The theory was this was an ongoing course of conduct, and my client was the mastermind behind this incident. And the prosecutor was using the phone call, which was ruled, the contents of the call were ruled inadmissible by the judge. And the prosecutor was using that to paper over the holes in his case for joint venture by means of a
Well,
knife and a
what
gun.
hole was he papering over? It seems to me that an inference that, well, number one, there was no need to show that your client was in the lead. That's not an element of witness intimidation, even on joint venture theory. But even if it were, your client was leading the parade up and down the block.
I would dispute that he was leading the parade up and down the block. He was first in line going one way. He was also first to leave the scene. And if you look at the video, when Cook and his family come out, it's not my client that confronts them, it's other members. My client's in the back. He's not leading anyone. He's behind everyone at that point. And only when he's confronted with Cook do you see my client out of that crowd. Now, I just want to mention the Commonwealth's argument is an example of a logical fallacy called post hoc ergo propter hoc. With regard to the phone call, the Commonwealth is arguing if A happens and then B happens, then A caused B, and that's clearly faulty reasoning and not the basis for an inference.
We'll have to stop right there. Thank you for your argument. We will now hear from the Commonwealth.
Thank you.
May it please the court, Special Assistant District Attorney Tara Johnston for the Commonwealth. Your Honors, as a preliminary matter, first, I just want to address the statements in the closing argument with regard to the phone call and also the Commonwealth's brief. The Commonwealth does apologize for its error as it's stated in its letter in the brief, stating that Barboza testified that DEBURGO made a phone call to the Hudson JP. What he actually testified to, and what's in pages 54 to 59 of volume 7 of the transcript, is that DEBURGO, when Barboza, DEBURGO, and Pellet returned to Barboza's house, that DEBURGO made a phone call. After that phone call, the Hunts and JP arrived. And when they arrived, they all walked over to the victim's home. Now, the Commonwealth maintains still, and this was the prosecutor's theory of the case, and this is what the prosecutor argued during closing argument, not that Barboza testified that the defendant made a phone call to the Hudson JP. Rather, his argument was that the evidence showed that was what happened. And that is still, and the Commonwealth maintains, that is the most reasonable inference from the evidence. And the transcript controls here, and it on pages 54 to 59, you can see the sequence of events here. And the sequence of events is that they get back to the house, defendant makes the phone call, those individuals arrive, and they all walk over to the victim's home.
So what's the correct standard of review? Mr. Power points to volume 8, pages 195, 198, 199. Those were the 3 objections. Were there any objections that referenced the phone call, either made by DEBURGO or not?
There were none, Your Honor. There were 3 objections, as you say, during the closing argument. Only one of those objections pertained to any of the issues that my brother is raising on appeal with respect to the closing argument. So none of those, and as I said, the transcript controls here, as the panel can see, there is nothing in the transcript that any of those objections were made regarding the phone call. One was made regarding the exchange that DEBURGO may have had with the other people, with the other groups, with the other individuals in the group when they walked over to the victim's home. One had to do with the prosecutor claiming, the defense counsel claiming there was vouching, and then another had to do with one of the prosecutor's statements. The defense counsel argued that they were trying to argue that DEBURGO's testimony, I believe, was not, I'm sorry, Barboza's testimony, certain parts should be accepted, perhaps in certain parts, or something of his testimony should not be accepted, or it should be accepted, but it did not have to do with, none of the objections had to do with that phone call. That would not, so if we look at the transcript, there is none. And so it is looked at under substantial risk of a miscarriage of justice, because we look at the objections, as this court well knows, as to what precisely was objected to.
So going back to the sufficiency, I'd like you to address Justice Sachs's question with respect to what the reasonable person standard is under intimidation of a witness. As I understand the defendant's argument, the appellant's argument, it's that we look at a reasonable person in the shoes of this particular defendant. So at least according to Mr. Power, I think he's saying we look to their age, their background, their experience. What is your understanding? What is the best case that defines what the reasonable person standard under the intimidation of a witness statute?
So I don't think any of the cases say that, and I don't think Commonwealth versus Rivera, which is the case my brother is relying on, say that. I think the reasonable standard is just an objectively reasonable person, and unless, say, they're in a specific role, such as a police officer, I don't think the court looks at every single individual factor about that person, because that would almost be impossible to look at that. My brother is asking you to look at each specific personality type that person has. Of course, that's not, that's just an unreasonable standard. We look at it from an objectively reasonable standard in the person's position, yes, but just an objectively reasonable human being. And also, I think this is something, as the panel has pointed out, I think it's very important here to remember that the question under this test that we're looking at of intimidation of witness is not actually whether the fear was accomplished, but whether or not a reasonable person, it would instill fear in a reasonable person. And I think when we look at the continuous course of conduct that occurred here, from the moment that the group of individuals walked over to the victim's home and started yelling out names, rat, snitch, approached Jalen Maciel, who is one of those victims' 14-year-old sister and another victim's 14-year-old cousin, and told her to get her badass cousin Ryan out of the house. Then during the altercation, we also have Elizabeth Cook, Ryan's mother, saying that I believe it was the defendant, but one of these individuals saying, wait until the trial is over. All of these individuals at the time, knowing that while Ryan Cook is outside, Tim Maciel Jr. is already inside the house, because there's testimony from Barboza that the defendant and the others saw them both outside the house before they went back to Barboza's house. So all of this cumulatively, plus you have Pellet swinging the knife and the defendant clapping his hands in encouragement. All of this continuous course of conduct contributed to the intimidation of a witness. Now, I do want to make two things clear here. I know my brother argues that part of the theory, and there was no evidence of knowledge about it on the part of the defendant, was DESHAWN Hunt's use of the gun. I want to make clear at the outset that while that may have been originally the Commonwealth's intention or to pursue that argument, that was not what was pursued by the Commonwealth. The Commonwealth, during the closing argument, the Commonwealth's theory of the case was not that DESHAWN Hunt's gun was, the Commonwealth did argue that that DESHAWN Hunt may have used the gun to impress the defendant, but in no way did the prosecutor suggest that that was part of the intimidation of a witness, or say that the defendant knew beforehand or knew at all about DESHAWN Hunt's use of the gun.
Well, why does that even matter? I mean, the jury is instructed you may accept part of what a witness says, none of what a witness says, or all of what a witness says. There's no bill of particulars here, as far as I understand. If a prosecutor says X in closing argument, which the jury is instructed is not evidence anyway, to my knowledge, that doesn't bind the Commonwealth to that particular statement. If it did, it would usurp the jury's role.
I think you're right. I think then we would be looking at, though, as whether or not kind of there was an error in the prosecutor's argument to argue something that there was no evidence of in terms of intimidation of witness. And under even under any standard, I could see how in this type of case that might be problematic when we're dealing with intimidation of witness, attributing DESHAWN Hunt's use of the gun to the defendant in terms of the intimidation of a witness charge, but that's not what happened here. And I just want to make that clear, that while I don't think that it would, be reason to reverse the conviction, that is not what happened here and should not concern the court, because that is not what the Commonwealth's theory of the case was. I think the prosecutor actually argued, even during the closing argument, he explicitly said, once that use of the knife, once that is done with, you have the act of intimidation is complete. It's complete. We had that continuous course of conduct, from the yelling out names, from what happens during the altercation, from the statements made during the altercation, and then by the defendant clapping his hands in encouragement. Now, I just also want to address a couple of things that my brother argues with respect to that applause is not enough. The Commonwealth would certainly disagree. When someone is, and I think that Commonwealth with Zanetti stands for this proposition. No, there was no clapping in Zanetti. Of course, it's a different set of facts, but we know that active participation is not necessary. Egging someone on or clapping your hands in encouragement while someone else harms someone else is acting as a participant in a crime. I think Zanetti and any other case in Massachusetts appellate court supports that. I don't think that my brother cites any case that would undermine that principle, that standing there and clapping in encouragement is enough is sufficient for acting as a participant. I also want to clear something else up. I know my brother in his brief cites Commonwealth versus Fregata, a 128 decision. And he says in that decision, he realized there was an isolated act. There was a continuous course of conduct actually, but the prosecutor's theory was based on an isolated act.
Wasn't Fregata an SJC decision as opposed to a 128?
I'm sorry, Your Honor. You know what? I thought it was you're right. It is an SJC decision. It's a 2018 SJC decision. I apologize. But it's not on point here, because what happened in that case is that there was an isolated there was a continuous course of conduct, but the isolated incident that the prosecutor argued as the basis for the witness intimidation charge, that occurred before the victim, before the victim in that case could be considered a witness in a criminal case. So the concern there was that one of the elements of witness intimidation had not been satisfied. And that was the concern there. And the prosecutor, rather than arguing the continuous course of conduct, he argued that that isolated act would be sufficient for the crime of witness intimidation. We don't have that situation here. First of all, the prosecutor argued the continuous course of conduct, from the yelling outside the house to the insults during the altercation to the clapping the hands while Pellet swung the knife. So this was the continuous course of conduct. And also, all of these acts, every single one, occurred when these victims were already witnesses in a murder trial, and the defendant was aware of that fact. So, the Fregata is just very much distinguishable for this case, and any reliance on it is misplaced. I also want to address another important argument my brother raises, which is that there was insufficient evidence with respect to Timothy Maciel Jr. Now, the Commonwealth, of course, disagrees with that argument. As I've stated, the defendant knew beforehand, not just that Ryan Cook was home, but that Timothy Maciel Jr. was home. Barboza did testify to that. He testified that they saw them both congregated outside the house with others before they went over there. So that was certainly something that the defendant knew. He also knew he's yelling outside their home, rat, snitch. Yes, most of the, or all of the comments when they say a name are directed at Ryan. The Commonwealth would agree with that. They also know that not just Ryan Cook's family members, but Timothy Maciel Jr.'s family members are inside that house. That when they approach Jaylyn Maciel, she's Timothy Maciel Jr.'s 14-year-old sister. That when that whole altercation is occurring, that's just not Ryan Cook's family members, that's Timothy Maciel Jr.'s family members as well. And I think the fact that there was some fear here is evident from the fact that Timothy Maciel Jr. is watching from the house, and he sees JP, the juvenile, playing with the drawstring of his pants, and he sees him with the gun, and he is in such fear that he comes out and takes the gun and shoots a shot in the air, because he is nervous about what is going to happen. So this whole idea that nobody was in fear, or that Tim Jr. Maciel was not a part of this, that is just not supported by the record. And I also want to point out just that the jury was instructed that they could find in witness intimidation as to one victim, both victims, or neither victim. There were two boxes. There's one indictment, there's two boxes, Ryan Cook and Timothy Jr. Maciel. The jury found it as to both. They checked off both boxes. That is supported by the evidence in this case.
Can I ask, there's an argument that Barbosa's testimony as an immunized witness wasn't sufficiently corroborated, and you said that it was corroborated on 2 of the 4 elements of witness intimidation. Can you just clarify which 2?
Yes, so one of the important ones is that acts of intimidation or threats. There's ample testimony from multiple witnesses outside the house that the defendant is saying rat, schnit, snitch. We also have him up clapping his hands, which we have corroboration from the video itself, Exhibit 7 at trial, which is actually available for the court's viewing, that he's clapping his hands as Pellet swings the knife. So there's multiple witnesses corroboration on that. And then also that these individuals were witnesses in a murder trial. So Ryan Cook and Timothy Maciel Jr. both testified that they had testified at the grand jury in this case, and that they were witnesses in a murder trial. So at least 2 of the 4 elements, there's corroboration on here by other witnesses at trial. And in terms of the closing argument, I see I'm running out of time.
I think we're going to have to stop right there. So, Justice Sachs, Justice Lemire, any further questions? No. Thank you both for your helpful arguments and your excellent briefing.
All right, we are live and recording.
Calling our next case, docket 2019 P1532, Commonwealth versus Hunt. We will hear first from counsel for Mr. Hunt, Attorney Riley.
Yes, good morning, distinguished members of the panel. If it may please the court, my name is Catherine Riley. I'm here on behalf of Mr. DESHAWN Hunt. I would first like to address the issue of the lack of evidence as to the length of the barrel of the gun Mr. Hunt was alleged to have held, a crucial element of the charge. Now, I know the court is familiar with the facts from the briefs and also from the previous case, but I believe there is a crucial point that needs to be made. Out of all the people present at this daytime shootout in New Bedford, and out of all the numerous witnesses, I believe it was 18 Commonwealth witnesses, only 2 of those witnesses testified to seeing Mr. Hunt with a gun. At first, there was Ryan Cook, and now Mr. Cook was not charged in connection with the illegal firearm he picked up and fired into a crowd. He was granted a non-prosecution agreement in exchange for his testimony. And the second witness was Mr. Barbosa, who also was not charged in connection with this case in exchange for his testimony. And that was despite the fact that he was the brother of the suspect in the murder case that was the basis for the intimidation of a witness charge. And it was his house that the defendants were alleged to have congregated prior to this shootout. But however flawed these 2 eyewitnesses were, they were still 2 witnesses that testified to seeing Mr. Hunt with a gun. And yet the Commonwealth did not ask them to describe that gun in any way. Ryan Cook was asked, "What did you notice about DESHAWN?" He responded, "He was pointing a gun at me." He was next asked, "What did you do?" and responded, "I shot at him." What he was not asked is, what did that gun look like? Was it a gun with a silver handle, like the gun the child supposedly had? He was not asked how the defendant was holding the gun. Was it with one hand or 2? He was not asked how big the gun was, or if the defendant had pulled it from his pocket, his pants, or if it was just hanging by his side.
Wasn't there testimony, I'm sorry to interrupt, but wasn't there testimony regarding the gun being in someone's sweatshirt or something to that effect?
I don't believe so. I have the testimony of Mr. Cook in front of me and Mr. Barbosa.
Or the gun was in the waistband, perhaps?
That was of the child, the juvenile referred to as JP in the Commonwealth's brief.
And there was testimony, I believe, from a police officer that they found 7 shell casings for 40 caliber. Is that correct?
Yes, but there was no testimony from that firearms examiner about what type of gun that came from, and no testimony about the barrel of the gun that would have come from.
Let's assume that it's a reasonable inference under the Lattimore standard that there was only one gun used by the defendant in the group. Okay, I want you to assume that as a fact, and that the gun was taken out of someone's waistband, and combine that with the video evidence. Why is that not sufficient to show, under the Lattimore standard, the barrel was less than 60 inches?
Well, I think that would have been, but there is no testimony because the 2 witnesses weren't asked where the gun that they saw Mr. Hunt holding came from. They weren't asked, did it come from his waistband? Did it come from his pocket? Both of them just testified they saw a gun. And for some reason, they were not asked to describe anything about it. And that is very curious because this was a long case that required several grants of non-prosecution. The Commonwealth knew what their witnesses could say and couldn't say, and they failed to ask the 2 eyewitnesses to Mr. Hunt holding a gun, the only 2 witnesses that saw him with a gun, what that gun looked like. It would have been easy to have gotten that information if it was available. I think if you notice,
Ms. Riley, this is
yes.
Judge Lemire. Just going back to Judge Neyman's question, though, there were shell casings found and testimony that the shell casings came from the same gun. So, isn't it fair to assume there was only one 40 caliber gun on that side of the street, and only one gun on that side of the street, and that the juvenile and your client may have been holding the same gun? Is that a reasonable inference the jury could make? And if not, not?
Well, I don't believe it's a reasonable inference. A lot of this was captured on camera. There's nothing on camera that shows the juvenile handing that gun to Mr. Hunt. Also,
well, it
there
shows
is
them
the
going
Commonwealth
off,
witnesses. I'm sorry.
it shows them going off camera, and then your client coming back with the gun.
Right, they went off camera because the other witnesses were shooting at them. But also, there's nothing on that camera that shows the juvenile passing anything to Mr. Hunt, and it doesn't show Mr. Hunt holding a gun. And also, the Commonwealth's witnesses picked up many of the shell casings from that area. They also, none of the Commonwealth witnesses actually testified to seeing the juvenile shoot the gun. The witness, Timothy Massale, said that, and I'm looking at his testimony. He saw the kid pull out his pistol. And what did you do? He fired his gun. And what happened? Then he ran, and then he heard all kinds of gunshots from back. So there's nothing that says that the child actually shot this gun. But it is also curious as to how the Commonwealth presented this case. Rather than grant the juvenile immunity from prosecution, they granted the brother of the murder suspect immunity. Had the juvenile testified under immunity, he could have said, I handed the gun, but he didn't. All the Commonwealth had to do was ask their 2 witnesses that they gave up prosecuting to have testify, what's the gun Mr. Hunt held looked like. And if you look at the case law, that I think if you look at both briefs, both the Commonwealth and the defense brief, we cite the same cases. There's DaCosta. The witness in DaCosta said he saw only fire, and he demonstrated in that case how the gun was held in one hand. Here, had the Commonwealth asked either Mr. Cook or Mr. Barbosa what the gun looked like, and they said, if they had said, I couldn't see, but I saw a flash and he was holding it in one hand, we wouldn't be here on this issue.
This is Judge Neyman speaking. Doesn't the video show at one point the gun being held in one hand?
I don't know which part of the video or who in the video you're referring to. My recollection of the video is that there's nothing with Mr. Hunt holding a gun. I think that the juvenile looks like he's holding something, and the witnesses to that were able to describe it. They were able to describe it as a silver handgun or a pistol. You know, if you look at Naylor,
Do you
the
agree
witness,
that, again, it was Neyman asking this question.
Yes, thank
Do you agree that the description of the firearm as a pistol assists the Commonwealth in getting beyond Lattimore, assuming that it was your client holding a pistol?
I would agree if either one of the eyewitnesses said Mr. Hunt was holding a pistol, that might be enough to get beyond Lattimore, but that's not the situation here.
So you're hanging your hat.
They declined to ask that
You're
question.
hanging your hat. I'm sorry. You're hanging your hat in your argument on the notion that there's not enough evidence to show that the pistol held by the juvenile was the same as the pistol held by your client. Is that correct? You're saying
Yes,
that it's reasonable?
Right, because they had two eyewitnesses they could have asked those questions of. I mean, if you look at Naylor, the court in Naylor stated in the absence of any statement by either victim having seen the barrel, there's sufficient evidence. But when the court there says in the absence, the witness was asked to testify to what they did see, and they said they saw a flash coming from what they thought was a gun in the defendant's hand. So if you played that scenario out in this case, had the Commonwealth asked Mr. Barbosa or Mr. Cook, what did you see? And they said the defendant's hand in a flash, again, we wouldn't be here on this issue. The Commonwealth decided, rather than elicit direct testimony from the two eyewitnesses, that they were going to ask the jury to make a leap in reasoning and to fill the gaps they could have filled with direct evidence with inferences. And that's just not fair. They were not held to their burden of proof. They had two witnesses they could have presented direct evidence from, and they didn't. If you look at Commonwealth versus Evans, the barrel in that case was inferred because the shooter removed it from a pocket. Here, the Commonwealth could have asked Barbosa or Cook, did he take it from his waistband? Did he take it from their pocket? In Sylvester, the gun in question was described as a handgun. Here, it was just described as a gun with no follow-up. In Manning, the shooter's stance was described along with his ability to conceal the weapon. I mean, it really begs the question, why wasn't this question asked? It wasn't as if...
I'm sorry to interrupt. I just want you to know you have 4.5 minutes remaining on your time.
Thank you. You know, I think the Commonwealth could have given the jury direct evidence, and for some reason they decided not to fulfill their burden of proof with direct evidence, and then argued in their closing, trying to make the jury infer that it was the same gun that the child possessed that Mr. Hunt was seen with. And as far as the firearms examiner, he stated he was not able to determine what type of gun those casings came from. Mr. Maciel testified to picking up numerous casings and to try to conceal them. And he testified after the juvenile was pointed the gun that he fired his own gun and then ran and heard all kinds of shooting, where the connection between the gun and the juvenile had. And why was the jury asked to infer that rather than given direct evidence?
So this is Justice Sachs.
Yes, thank you.
Are you asking us to draw an adverse inference from the Commonwealth's failure to ask these two witnesses to describe the gun they saw in your client's hands?
Well, I'm asking the court to say that there was not sufficient evidence for the Commonwealth to first argue that the juvenile gun was the same gun.
I'm sorry, it seems like a major part of your argument is to point to questions the Commonwealth didn't ask. And I agree the focus should be on what the evidence was rather than what it wasn't. So
well, I mean, I believe that
questioning whether we can draw an adverse inference from the Commonwealth's failure to ask these questions of the two witnesses. Should we infer that the answer would have been it was a gun with a barrel longer than 16 inches?
Yes, I think every inference should, since it was their burden of proof, should be in the defense's side.
Under
The
Latimer?
problem, I am asking the court to find that there was insufficient evidence that any evidence on the barrel side. And I think it is curious in the Commonwealth's brief on the next case, they state in their facts section that as each defendant was walking down the street towards the next house, Mr. DEBURGO, one of the defendants, had a bat, Mr. Hunt had a gun, the juvenile had a gun, inferring that there was more than one gun. I think this was a leap of inference not based in the facts presented at trial, and there was no facts as to the barrel's length. So where there is an absence of facts, I think the inference should be towards the defense.
And you have a minute and a half remaining.
Thank you. So as far as the closing, I think, again, the Commonwealth impermissibly asked the jury to infer that the gun held by the child was the same gun held by Mr. Hunt. And they did so under the circumstance where they could have elicited direct testimony to that. And also, just as far as the rest of the closing argument, I would rest on my brief, and I know it was discussed in the argument previous to this case. Thank you.
Thank you. Any further questions, Justice Sachs or Justice Lemire? Seeing none, we will now hear from the Commonwealth. Thank you, Attorney Riley.
Thank you.
May it please the court, Special Assistant District Attorney Tara Johnston for the Commonwealth. Your Honors, the most reasonable inference from the evidence in this case was that the gun that was used by DESHAWN Hunt, the defendant in this case, was the same gun that was used by JP. First, there was no other evidence in the case of anyone else having a gun. What we know is that when all 6 individuals in the group are congregated outside, outside during the altercation, Tim Maciel Jr. sees one person with a gun, a silver handgun. That is JP. He lifts it up and starts shooting. Then everybody runs off camera. Moments later, DESHAWN Hunt returns. We cannot see the top of his body on the camera. We can only see the bottom of his legs. We know there's testimony that he's shooting a gun. And we see the bottom of his legs in that same area where JP was shooting the gun from, 25 Thompson Street, the house diagonally across from 30 Thompson Street. And then what do we know? We know that there's an investigation. The police come to the scene and they find 2 sets of bullet casings. One from the gun that was used by Ryan Cook and Tim Maciel Jr., and those are found at 30 Thompson Street, and another set of 7 bullet casings at 25 Thompson Street, the location where JP shot the gun and the location where the defendant shot the gun. And the officers testified that they all came from the same firearm. That evidence taken together is sufficient to show that the most reasonable inference is that that was the same gun. And I just want to make clear, because there's some discussion about what was argued in one brief as opposed to another brief. I can't speak to what was argued in any other brief, but I can say that the Commonwealth's theory throughout trial, and it's very clear, was that it was one, and the gun was one and the same, that there was one gun here, and that the same gun that was used by, the gun that was used by JP was the gun that was used by DESHAWN Hunt. That was the Commonwealth's theory throughout the trial. And the Commonwealth made that clear during closing argument. I know my sister argues that there are, as she stated, we both are relying on the same cases, but those cases are important because those cases show that you do not need direct evidence from a witness as to the appearance of the gun. The requirement, you can meet the standard with circumstantial evidence. That has always been the standard under Lattimore. And my sister is asking to draw an adverse witness by asking this court to consider what the Commonwealth could have potentially presented. That is not the standard. That we don't dissect the Commonwealth's case and say, how should have they presented this evidence? Was this the best way to present it? What we look to is whether or not there was sufficient evidence presented for a reasonable true or fact to determine that Hunt had a gun with a barrel length of less than 16 inches. And here the answer to that question is yes. We cannot speculate as to why those witnesses were asked. Perhaps the prosecutor knew they didn't see it. We don't know. We can't speculate as to that. We can't speculate as to what's not in the record. What we have is what is in the record, is what is in the transcript. And what is in the record and what is available from these witnesses' testimony, and the most reasonable inference is that the same gun that was used by JP was the gun used by the defendant. And we have the physical characteristics of that gun, which is far more than we have in some of the cases that my sister and I cite, that where there was determined that there was sufficient evidence. We know that it's a silver handgun. We know that it's easily concealable in the waistband of somebody's pants. So there's no question, and my sister doesn't seem to even contest the fact that if it's the same gun, that the evidence is sufficient in this case. Her whole argument seems to depend on this idea that there can't be a reasonable inference drawn that it was the same gun. And clearly, I think it's apparent that there can be. Also, we have to consider the timeline here. That group of 6 individuals runs right off. JP, you see him run right off camera. And then moments later, DESHAWN Hunt returns with the gun. There's no evidence of him stopping anywhere. There's no reason why. I mean, there's no evidence that he got some long shotgun during the moments between the time that JP ran off camera and the time that the defendant returned to shoot at Ryan Cook. So taken cumulatively, as I said, the most reasonable inference from all of the evidence here is that the gun used by JP and the gun used by the defendant in this case was one and the same. Turning, I don't know if there's any questions further on the sufficiency portion, but otherwise I will turn to just briefly the closing argument portion. As the Commonwealth states in its brief, first of all, the two issues that my sister raises on appeal, both of them we look at again under the substantial risk of a miscarriage of justice standard, because neither were objected to. Whether or not we give the defendant the benefit of any objections raised by DEBURGO's counsel, it really doesn't matter, because none of those objections, regardless of whether we give him the benefit of those or not in this case, none of those objections were to the claim she raises on appeal here. One is that one argument is, of course, that it was reasonable for the prosecutor to argue. It wasn't based on the evidence for the prosecutor to argue that the gun that JP used, and there was one gun, and the gun that JP used was the one that DESHAWN Hunt, the defendant, used in this case. As it's already been addressed in the sufficiency argument, everything the same applies here. There was sufficient evidence for the jury to draw that reasonable inference. So, and that the prosecutor's entitled to argue not just direct evidence, but circumstantial evidence, reasonable inferences from the evidence, and that is what he did in this case. And then, of course, the second issue, which has already been addressed in DEBURGO, as my sister stated, but the Commonwealth reiterates the most reasonable inference from the testimony was that, first of all, I want to make clear that this is a joint venture case, and regardless of that phone call, and also here for the defendant, the firearm charges, the phone call here is largely it's inconsequential here. It really doesn't matter who that phone call was to. But in terms of just the prosecutor, what the prosecutor stated in closing argument, the prosecutor was completely correct in stating in closing argument that the evidence showed that that DEBURGO made a call for the Hunts and JP to come over the house. That was the most reasonable inference from the evidence. As far as any wording in the Commonwealth's brief saying that that Barboza testified that DEBURGO made a call to the Hunts and JP, that's already been addressed. The
Commonwealth. Right, we've addressed that issue. So let's see if there are any further questions from the panel. No, seeing none, is there anything else you'd like to tell us?
I think that covers both of the issues. So if there's no other issues questions from the panel, the Commonwealth will rest on its brief. Thank you.
Thank you, Attorney Johnston. Thank you, Attorney Riley, for your excellent brief.
All right, we are live and recording.
Calling the next case on our list, docket number 2019 P1531, Commonwealth versus David Pellet. We'll hear first from counsel for the appellant, Mr. Lovins.
Thank you, members of the court. At the outset, just a couple of administrative things. First of all, in reviewing my brief last night, I noticed I had a couple of misplaced apostrophes, and I want to apologize for that. Number two, I want to note that in the event that I do not make an oral argument, I made in the briefs that we're not waiving that. And so, insofar as the argument on behalf of the appellant, I believe that the argument on the issue of witness intimidation could begin and end with the statute itself, in that there was sufficient evidence that was presented, because that's going to require that the defendant Pellet knew that these folks, Cook and Maciel, were in fact witnesses or potential witnesses. There's no evidence that I know of that the Commonwealth introduced that shows that. So that's my starting point, and it could be my ending point, but it won't be. I want to go on to say that the facts in this case are important because they are chaotic. It's never clear as to who fired first here, who was firing at who, whether they were firing at individuals or buildings. But it is interesting that the people who are crying foul here, that is Cook and Maciel, went to great lengths to hide bullet casings and lied about the surveillance functionality. The statute requires that there be some kind of emotional or attempted emotional injury or physical injury, and there's no evidence of that either. What is clear is that the defendant, Pellet, with his cohorts, went to the Barboza house for the singular purpose of, quote, hanging out, close quote. And that, I believe, is important because that goes to the intent of why they were there and whether they were there for the purpose of intimidating the witnesses, the alleged witnesses. The Commonwealth seems to rest its case heavily upon the fact that someone cried out rat or snitch on more than one occasion, but it is clear that no one ever identified who that was. And when you put together the fact that they were there to hang out and that there is evidence of that, because they said they were there to hang out, and the fact that you don't know who said rat or snitch, then all you're left with, or all the jury is left with, is speculation. And as we know, that's not allowed for a verdict. As to the law of joint venture, because if the Commonwealth cannot hang Mr. Pellet on his individual conduct, then they would try to do so on a joint venture. He needs to be at that location with knowledge that the others intend to commit a crime. Again, there's no evidence of that. People ultimately display guns. There's no evidence that he knew that they arrived with guns, that they intended to use guns. And again, there's no evidence as to who it was that fired first.
Attorney Lovins, do you agree that if the evidence is sufficient as to either individual liability or the joint venture liability here, that satisfying either one means that we would be obligated to affirm the conviction?
I do.
Thank you.
Okay. Going on under Zanetti, we know that mere knowledge that a crime is to be committed is not sufficient, and we don't have any knowledge that Pellet knew that a crime was in fact going to be committed, and that mere presence at the scene of a crime is not enough. But
you do have, there is evidence, as we see in the video, of 6 individuals walking in a line down the street directly across from the victim's house and looking over toward the victim's house, and then walking back from there. There is evidence that Mr. DEBURGO and perhaps another individual was yelling things like rat and snitch. And then there's evidence that during the confrontation that ensued, your client took out a knife and began swinging it at different people and was walking toward them and approaching them in a sort of a rapid manner while swinging at least the hand that was carrying the knife. Aren't all of those, isn't all of that correct under the Lattimore standard?
Well, that is correct. However, if the question is, what does it mean? Was it and what does it amount to? Remember, we don't know who it is that fired shots first.
Isn't that for the jury to determine? Isn't this a classic question of credibility and weight that juries decide each and every day?
Well, only if there's enough evidence for them to do that. And it doesn't seem like that there is enough evidence for the jury to determine who it is that fired first.
Why does it matter who fired first?
I'm sorry?
Why does it matter who fired first? What element does that go to?
Well, because that would go to, I think, not only, it would go to the intent argument of why a Pellet was waving this knife. For example, if he was waving this knife to hold these people off, that would be different from his waving the knife to attack these people. But isn't
it undisputed, at least from the video, that the swinging of the knife occurred before there were any gunshots?
I'm not sure that I agree, or that I can agree or disagree with that.
Okay, even if it's not undisputed, under the Lattimore standard, isn't there sufficient evidence that for a juror to believe that the swinging of the knife occurred prior to there being any gunshot?
No, because if we don't know, then we're engaging in speculation. And
well,
as
there is a video that shows the swinging of the knife and the parties separating, and then we see an individual come running out of the house, and we see that there are gunshots going back and forth. It seems to me one could watch that video, or a rational juror could watch that video and conclude that the swinging of the knife occurred prior to there being any gunshots.
I just am not sure that I agree with that conclusion, that the gunshots occurred after the swinging of the knife. I don't think that they did.
Well, let's assume for the time being, hypothetically, that the swinging of the knife occurred before the gunshots. What remains of your argument?
That the swinging of the knife occurred before the gunshots?
Yes.
I would say that well, the jury could conclude, and I think that this is a Lattimore issue, but the jury could conclude that the swinging of the knife was a response to this group of people, the Cook and Maciel people, coming towards them, coming towards Pellet and his associates, even without the gunshots being fired. And in fact, the waving of the knife had the desired effect by holding them off, and they were backing up.
So you're saying the jury could have concluded, in essence, that the use of the knife was in self-defense and defense of the others in Mr. Pellot's group, rather than an attempt to intimidate the group coming from the Maciel Cook side of the street?
Exactly. And remember that, again, we have to keep in mind the reason they were there, quote, hanging out, close quote. And there was no evidence of them planning to be there for intimidation or talking about intimidation. They just...
If we just back up a second, if we assume that the jury could have concluded that the knife was used to defend Mr. Pellet and his group, was the jury required to conclude that, or could they also have reasonably determined that the knife was used to intimidate the Cook Maciel group?
Not unless there are some subsidiary facts on which they could base that, and I don't see that they exist.
Well, your client was part of the group of 6 or 5 who were parading across the street. The evidence was that the group was yelling snitch and rat and come on out here. And the whether your client was at Mr. Barboza's house to hang out or to do something else, whatever his original purpose for being there, the fact is that he didn't remain at the house. He came out and participated in the parade and then stepped out into the street and pulled the knife out of his clothing. So taking that together with him beginning to swing the knife at the group from across the street, why isn't that sufficient for the jury to conclude that he was engaged in witness intimidation and assault with a dangerous weapon?
Well, I think we need to take them separately. The assault with a dangerous weapon is a separate consideration. But I think that for the jury to find him guilty of witness intimidation, there has to be something on which the jury bases his intent to intimidate. And I don't see that that's there.
Okay.
Anything further?
Sorry, Attorney Lovins.
Sure.
Not sure if you can see
And
the
for
clock.
a joint venture, the defendant needs to have knowledge of the principal's original intent. There's no evidence as to what the principals, meaning DEBURGO and the others, originally intended to do. In fact, the first time that Ryan Cook's name came up was when he drove by the premises. And that is confirmed at a transcript location that I noted in the brief. As for the assault, just very briefly, the one case that I did cite there stands for the proposition that there has to be an ability, capability of committing the crime, and with that weapon, I'm saying that there was no ability to commit that crime.
Thank you, Attorney Lovins. We appreciate your argument. Let me just
Thank
check
you.
the panel. Any further questions? Okay, seeing none, thank you, sir. And we will now hear from the Commonwealth.
Good morning. May it please the court, Stacey Gothier for the Commonwealth. The defendant's convictions for which affirmed. Oops, sorry.
Nope, you're back. Go ahead.
Should be affirmed as the Commonwealth presented sufficient evidence to support the convictions. On the intimidation charge, looking at the evidence in the light most favorable to the Commonwealth, the defendant was ready and willing to assist in the intimidation of Ryan and Tim Jr. He came to the scene armed with a knife, and he participated in walking back and forth in front of the house of a witness on a murder case, while somebody in the group was yelling, yo rat, hey rat, he's a snitch. And the defendant participated also by pulling out the knife and swinging it at Ryan and his family while they were out on the street. And certainly, the defendant was more than merely present at the scene. In pulling out the knife, that was that made him an active participant. And participation in an offense may take the form of aiding or assisting in the acts that constitute the offense. And the agreement to act in furtherance of a criminal enterprise, it doesn't have to be formal or explicit. As long, it's enough to just consciously act together before or during the crime with the intent of making the crime succeed. So I would suggest that in these circumstances, the Commonwealth certainly presented sufficient evidence as far as the intimidation of a witness. And then with regard to the assault with a dangerous weapon, the judge, he instructed on attempted battery and threatened battery. And with regard to the attempted battery, I mean, the jury certainly could have inferred that by swinging a knife in close proximity at the victim and his family in the middle of a heated argument and then moving towards them, that the jury certainly could have inferred that he attempted to harm them. And with regard to the threatened battery, even if the defendant didn't actually intend to stab them, the jury certainly could have inferred, again, that by pulling out a knife and swinging it at the victim and his family in the middle of a heated argument and moving towards them, that was certainly that's sufficient for a threatened battery. If you watch the video, you know that as soon as he starts swinging, everybody immediately moves back. And at one point, he got pretty close to Jaylyn while she was trying to help her father. So I would suggest that was, that the evidence was sufficient to constitute an assault with a dangerous weapon, either threatened or, attempted. And I just ask if the panel has any questions.
I think one of the things, maybe I misunderstood him, but Attorney Lovins indicated there was no evidence that they were witnesses or something to that extent. It's my recollection they both testified that they had testified before the grand jury prior to that date.
Yes, Your Honor. My memory is that at the time of the incident, both Tim and Ryan had testified in front of the grand jury.
And there was testimony by them at that trial that they had testified before the grand jury.
Yes.
In other words, yeah, okay.
Yeah, that's my memory. I don't have a specific site off the top of my head, but that is my memory that came out that they had both testified. And I know that Barboza had testified that there was that Ryan had a problem. Ryan and DEBURGO had a running feud going on. That also came out at trial. And just to go back to my argument on the assault with a dangerous weapon, the defendant had argued that he didn't think that it was sufficient because the knife didn't have the apparent ability to commit the threatened act. And I just point out that I would suggest that it did. That the witnesses had testified that they could see the blade. They testified that the knife was long. Albert Cook testified that it was about 6 to 8 inches in length, that it was attached to brass knuckles. And they had testified that it was either the blade was sticking out either by the defendant's hand, the side of his hand, or his forearm. And you'll note in the video that when he first came out and swinging, he kind of went up like that, almost like he was going to punch. And that was where the witnesses had described the blade. And if there's no further questions, I'll rest on my brief.
Seeing none, thank you very much, counsel. Thank you both. We appreciate your arguments and your briefing, and the case is submitted.
All right, we are live and on the record.
Calling our next case, docket 2020 P773, Crowley v. Randazzo. We will hear first from counsel for the appellant.
Thank you. Thank you. Good morning. Matthew Barrick for the appellant. May it please the court. We are requesting today that the judgment of the lower court be vacated and remanded, as the lower court committed a clear and reversible error by failing to hold an evidentiary hearing prior to dismissing the wife's equity complaint for division of an undivided marital asset. The fundamental purpose of the probate court and family court's equity jurisdiction is to ensure that the interests of justice are served. This grant of equitable power extends to actions necessary to afford any relief in the best interest of a person under the court's jurisdiction. The interests of justice have not been served in this matter before you today due to the failure to conduct an evidentiary hearing on the wife's equity complaint.
Was an evidentiary hearing requested?
Yes. I mean, we brought a complaint in equity. There was a motion to dismiss. We had an argument and it was dismissed. And in fact, that's the great tragedy of this case, is not only do we have a dismissal, but on that dismissal, the lower court writes for its reasoning, provides no reasoning, no how, no why, and writes res judicata twice. Now, I don't know what res judicata twice is, but that's the stated reasoning. So not only were we not afforded the opportunity to be in front of the court and provide evidence, but we don't really have an explanation or rationale as to why it was dismissed.
So our review, I'm sorry to interrupt, but our review is de novo and we're bound by the four corners of the complaint. Is that correct?
Yes, I agree with that.
So that begs the question, which is, what relief was being sought in the prior contempt action?
Well, in the prior contempt action, there was 4 claims. One of the claims was to compel an equalized division of the barred account. But as we have held by the SJC in the Bernier case, a complaint in equity differs from a complaint for contempt. And I think what happens here and why it's so important to go back to how the judge dismissed this is that the judge did not distinguish Bernier, which is controlling precedent as to why this case should not have been dismissed. It's a premature dismissal.
Does Bernier go only to the propriety of giving preclusive effect to the contempt judgment, or do you contend it also goes to whether the original divorce judgment should have been given preclusive effect?
I think it could potentially go to both.
Well, how does it go to the divorce judgment?
I mean, well, the divorce judgment, I think, is answered by the record that we have. The record that it was not included in the party separation agreement what to do with the gains or losses of the barred account.
Well, it said divided equally, $151,805 to the husband and to the wife, and the quadros to be completed by the end of 2013.
But here's the problem. Divided equally was the essence of the contempt judgment. And a contempt judgment has a higher, or contempt proceeding has a higher evidentiary standard. It has to be by clear and convincing evidence, and it has to be a clear and unequivocal order.
But we were talking about whether the divorce judgment should have been given preclusive effect. So put the contempt judgment aside for a minute. The divorce judgment, by incorporating the separation agreement, said divided equally by giving the wife $151,805 and complete this by the end of 2013 through a quadro. So I don't understand what was left open if the judgment provided for this equal division in a specific amount to be completed by a specific time. Now, the fact that it dragged on after that time and no provision was made for it to be what would happen to any gains and losses after the end of 2013 doesn't seem to me to be a reason not to give the divorce judgment preclusive effect.
Well, because the problem is, the issue is, and I think that goes to the question of a contempt, the issue is divide equally. So the wife's position as part of the contempt judgment was divide equally means that you divide it inclusive of gains or losses in the account.
Well, you might have a stronger argument on that if it hadn't included the dollar amount. And said that the division was to be accomplished. I think the judgment was September 2013, so that left a little more than 3 months to complete the quadro.
But see, the problem is that in the contempt judgment, the judge found that he could not adjudicate the husband in contempt for not dividing the quadro. But however, the judge pointed to the fact that he inexplicably, the parties had left silent the provisions of gains and losses. So now at the end of a contempt judgment, and to your point right now, the question still remains. We're still begging the question, what do we do with those gains? And the judge did not address that in the contempt judgment.
But
and
counsel, going back to Judge Sachs, if the quadro had been completed by the end of 2013, we wouldn't have this situation theoretically, correct?
No, I don't know if I agree with that. I'm not going to concede that point, because you still have the fact that the gains, or if there had been losses in that account, was not concluded as to what to do with those. That was the point. That's why, in fact, it wasn't, I think, in part submitted to the quadro administrator to have the account. It was left open, and that's the problem. And see, that's why we have the equitable. That's why the equitable powers are so broad, and that's why the SJC and Bernier has rejected that reasoning that a contempt judgment differs from a complaint in equity. Because I'm not.
You know, I'm sorry to interrupt you, but you say that the question was left open. The divorce judgment said divide equally by giving the wife $151,805, and then in the satisfaction of rights provision, which is on page 2 of the separation agreement, for, again, incorporated into the divorce judgment, says the husband and wife agree they will not at any time or under any circumstances make any demands or claims for property except as otherwise provided in this agreement. So isn't that essentially like an integration clause in a contract that says anything not provided for here is there's nothing else that's due? So there's not going to be any claim for any property beyond what is specified in the judgment, which in this instance is the $151,000 and some dollars.
No,
in that sense, the judgment does make a provision for if there are gains or losses. If there'd been losses, the husband would be stuck with them. If there'd been gains, the husband enjoyed them.
But that's not what the lower court found. I mean, in the contempt judgment, the lower court did not reach that.
But I'm asking about the divorce judgment. Why didn't the divorce judgment completely resolve this issue? And if there had been any ambiguity, certainly the wife at that time had the opportunity to get it clarified. Now, when the judge later said, well, it's inexplicable that there's no provision for gains and losses, but there is a provision under satisfaction of rights that says anything not provided for here, there won't be a claim about it later.
I think that it wasn't addressed by the parties. I think that I think you still at the end of the day, we still come back to the fact that the parties, as part of their separation agreement, and I think where the lower court was right in the contempt judgment, is that almost every separation agreement between parties deals and contemplates gains and losses up until the time of division. That clearly did not happen here. It is left silent. And the court, in its contempt judgment, found the same thing, that it was inexplicably silent. There is no disagreement that any gains that flow out of that account has not been divided. And our equitable statutes in the probate and family court differ. It says at any time a complaint can be brought. So the
Right.
fact that this complaint was brought later and has not been divided, we do not have a situation where it says the husband's going to receive those gains.
Well, at any time means if there hasn't been a previous provision in the divorce judgment itself for the division of property. And here there was a provision for quite specific about the barred 401k.
But again, not regarding any gains or any losses.
Well, let me, so I'm clear, what should have happened by the end of 2013 with those accounts?
I think it should have, at that point in time, it should have been divided, but part of the argument.
It should have been divided so that
pursuant to
151 was in her name alone and the other was in his name.
Yes, but we'd still have a claim.
That didn't happen.
That didn't happen.
And
I
so
wasn't there, but that didn't happen for a variety of different reasons.
So is the fact that that didn't happen is the error here. In other words, it was clear the parties were separating that account evenly at the time it was identified, and that half was going in one name and half was going in another name by the end of the year. That's what on paper the judgment indicated, correct?
Correct.
But because it didn't happen, the account grew as a total account, and now there was no division of the gain because somebody didn't divide it when they should have.
That's correct. And I think that's precisely why a hearing needs to be held, because I think that's a fact that needs to be addressed on the merits as to when this account should be divided, what happened before, and that's the purpose of equity. Equity is about fairness. And, we're not arguing today, I want to make it very clear, I'm not arguing to you that these accounts need to be divided with the gains, and then my client's entitled to half. What I'm arguing is that we're entitled under Bernier and his progeny to a hearing in front of the lower court and a proper judgment, and to be able to make that case that you're making. Why wasn't it divided? What was the intention of the parties?
Along those lines, was that hearing essentially conducted during the contempt hearing?
Well, we're missing, I'll point out one thing in the record, which is another reason why I think we have an incomplete picture here, which requires hearing. We're missing the second day of test. I didn't do the contempt hearing. We're missing the second day of testimony. We only have the wife's testimony in the contempt hearing. So I don't know that apparently the tape was lost, but regardless, I still come back to this. The issue is the barred account, those gains, because we're talking about the gains, not just the barred account and when what was supposed to happen with that 151 each. We're talking about the gains. What was concluded by the judge is that it was silent on those gains. And that's the point, that we haven't made that determination.
But it was silent because what's happened now was not expected to have happened. The judgment anticipated that the account was separated by the end of the year.
I disagree with that because I'll tell you why, from a practical standpoint. You have, in the probate court, and this is why the judge mentioned the attorneys that were involved, separation agreements routinely have the words gains and losses because there's always a lag between the judgment and the time that it's divided. That is commonplace. And because of that, that led to this problem. But the problem still exists. I'll put it this way. The interest of justice requires a hearing because if the reverse was true, certainly the husband would be arguing that the wife should share the losses. Any way you look at this, we're still stuck with the same problem. What to do with those gains and the broad powers that have been afforded by the legislature to the lower court and the probate court to administer justice and fairness And that's what we're seeking, what we're asking for. And at a minimum, we're entitled to a hearing to address those concerns. We might not succeed at the lower level if this is brought back, and it should be brought back. We might lose that hearing because of some of the arguments that you're bringing up today. But at a minimum, we're entitled to make those hearings, and we're entitled to a judgment that explains itself and explains how this case differs from the Supreme Judicial Court's case in Bernier, which is precisely on point, where an equity claim was brought after a complaint for contempt, where orders said the word equal of income, and it was dismissed for the very same reasons we're here today. And that's what the probate court does. We're supposed to adjudicate things fairly and justly until the time that we have the opportunity to have a hearing on the merits to determine what to do with those gains. Justice has not been served in this matter. And I ask you that Bernier controls to send it back and allow us to have a hearing and see where it ends up in the end.
Just one quick question. I apologize. The contempt decision that made no ruling on what to do with the gains, correct?
Correct.
Thank you.
Therein lies the problem.
I have one final question, and that's
Sure.
with respect to the transcript that is missing that you just referenced. Was there a motion to modify or correct the record, or any motion under Rule of Appellate Procedure 8 to supplement the record and tell us what we're missing?
No, because our take on it was our argument was contained within the briefing that we had done, and we didn't appeal the contempt. So we didn't do it, and my sister didn't do it either.
Thank you.
Thank you, Justice.
We will now hear from Attorney O'Connell.
You're muted.
Take off mute.
I apologize for that. Good morning. My name is Patricia O'Connell, and I am here on behalf of the appellee, Nicholas Randazzo. The lower court properly dismissed the, I will call it, just for without any disrespect, I'll call them the wife and the husband, and I'll refer to the complaint for distribution of undivided assets as the wife's distribution complaint. The lower court properly dismissed the distribution complaint on the principles of res judicata, which encompass both, as you know, issue preclusion and claim preclusion, although they're very similar. The distribution of the barred 401k has been a subject of litigation since prior to 2013. It was actually considered and necessarily decided in connection with the parties' judgment of divorce nisi. Both parties had counsel throughout the proceeding. It was a litigated proceeding. The separation agreement that they entered into with the advice of counsel and confirmed that they signed voluntarily and with full knowledge and understanding of the ramifications had a specific provision for a sum certain. It said the barred 401k will be divided as follows, and it was $151,805 to the husband and the same amount to the wife. It's correct that there was no language that said, and any gains or losses that addressed that issue specifically with the language about gains and losses, but that's because it was implied in the waiver of claims and the waiver of any further property rights and a waiver of any further claims, which is contained within the agreement. The court found in connection, and this was Judge Phelan, who was the same judge who heard the case on our motion to dismiss the complaint for distribution. The court found that in the contempt action, that the reason that the account wasn't wasn't divided in 2013 when it should have been, was not because there was any evidence that the husband delayed the process or thwarted it. In fact, he allowed the wife to actually draft the quadro herself, and there are multiple versions of that, and all of this is reflected in the record. And fully 8 months after the judgment of divorce nisi entered, she submitted the first quadro. She submitted the quadro that was ultimately approved in the dollar amount of $151,805 to her, despite the fact that at that point in time, the balance of the barred 401k had risen. So to claim that this wasn't a comprehended issue and that gains and losses are something new that could have that now has to be addressed and wasn't considered at the time is just disingenuous when you consider both the fact you have a waiver, you have the specific number for the lump sum transfer via quadro in the agreement, and a waiver to any further property rights that couldn't have been more clear.
All right, but counsel, help me understand this. If it had been transferred back in 2013,
yes,
which was anticipated by the judgment,
yeah,
then she would have had the benefit of some growth in that amount of 151 over the next 7 years.
correct, Your Honor.
But it wasn't transferred.
That's correct, Your Honor. And but the delay in transferring had nothing to do with any action taken by the husband, which was specifically found by the court in the contempt proceeding. In
Right,
fact,
but that's why he wasn't found in contempt, because he was not in direct violation of a court order of some specificity. So was there a decision as to what to do with that unanticipated gain that the husband acquired because of the failure of the quadro to be divided?
well, first, I'm not sure I would say that it was an unanticipated gain, because the husband also accepted a set number for other assets that went up and down since the actual entry of judgment. And the fact that that this one asset grew over time, does that mean then it's the slippery slope argument? What does it say about finality if we tell litigants after the fact, where you have a surviving agreement with a waiver of any further property claims, and there's a set dollar amount for distribution, and one party refuses to take the distribution, and the court finds that the lack of distribution wasn't in any way related to any effort to prevent it by the other party? What does that say about finality, and what does that do to the meaning of a waiver of claims? And does that mean that years later, litigants can come back and file a complaint in equity in the probate court and say, you know what, my attorney didn't put in that agreement the standard language that should have been in there, or that I wanted in there. So now I'm going to come back and say, well, I didn't know, it couldn't have been anticipated.
Well, explain to me why it wasn't fully done in 2013.
So the barred 401k was managed by the husband's, his employer. And for whatever reason, the wife decided that she wanted to draft the actual quadro, even though she had no experience in drafting the quadro, which is a finding of fact that the lower court made in the contempt action. She, and the findings show that she did multiple versions of the quadro before it was finally approved. It was approved for the amount of $151,000 8 months after the divorce. She clearly contemplated that that was the amount that she was supposed to receive under the terms of the agreement.
Back then?
Yes, and she didn't add language into the quadro plus or minus gains or losses since that time. So the wife's comprehension of what was required was clear. In terms of the contempt action, what I will say about that is the lower court in this case, Judge Phelan, treated the action as a motion for clarification. And it's very similar to the Colorio case that we cite in our brief. And in that case, there was a question in the party separation agreement. It said that the husband was supposed to transfer a fixed sum minus debts, half of debt that had accrued since May 1st. So the husband understood that this buyout for the home meant that he could deduct half of the mortgage as a debt. The wife said, no, that was the equity payment, that you don't get to further deduct the mortgage. So the agreement wasn't clear. and both parties had different interpretations as to what was meant by the debt. And the court said, I can't find you in contempt because it wasn't a willful violation, but both of you are asking me to do different things in terms of what has to happen now. And that's exactly what Judge Phelan did here.
But and again, I don't mean to jump. Judge Phelan just decided he wasn't in contempt. He didn't make any determination as to what to do with any growth.
Well, I would say, Your Honor, that he did, in that implicit in the judgment that the husband has to transfer only $151,804, and that the wife would be responsible for any further costs of implementation. It's implied in that he has no further obligation to further distribute any amount. And that fact is backed up by the fact that on the motion to dismiss, Judge Phelan considered it. He said res judicata twice, and my brother had said, I don't know what that means. I think it's clear he meant that the issue of the disposition of the barred 401k was decided at the time of the party's divorce. It was thoroughly litigated as an issue. What did this provision in the agreement mean? And each party had a different take on it. And the court at the end of the contempt hearing said he's not in contempt on that issue, but all he has to transfer to the wife is this set amount. And when we filed the motion to dismiss this complaint, this would be the third time that this issue has been litigated before the same judge. This judge, who was the one who heard that trial, said res judicata and actually awarded my client 100% of his legal fees requested.
And again, I apologize for not fully comprehending as to what didn't happen in 2013 and why didn't it happen?
The wife.
She drafted it.
Yes.
It has a specific amount.
Yes.
Is it my understanding that that amount should have been put in her name in an account?
So the specific amount in the quadro, that quadro that she drafted was sent to the plan administrator for the barred 401k. The plan administrator.
In May of 2014, correct? So the mother took from September 2013 to May 2014 to draft the quadro.
Correct.
Is that why it didn't get done in 2013?
Yes, there were multiple versions that went to the BARD administrator that were rejected, but ultimately, and for issues of language and technicalities, yeah. Ultimately the quadro for the $151,000 and odd dollars was sent 8 months later. The plan administrator approved it. This is in the evidence from the trial on the contempt, provided the pre-approval to the wife, at which point typically the parties will do a joint motion to implement the quadro, and the wife refused to do it. And during the pendency of the contempt proceeding.
All right, so just let me stop you there. The wife refused to do that back in May of 2014 up to the current time.
Correct.
And as a result, the amount stayed joined in one lump sum, gaining interest.
Correct.
It's just the math part that I have problems with.
I understand, Your Honor.
So just so I'm clear on your argument, it seems to me that the judge clearly did treat the contempt complaint as at least a contempt complaint, because he said the order in the separation agreement is clear and unequivocal and states with certainty an amount to be given to each party, $151,805, and the quadro is to be done in 2013. So he certainly adjudicated the contempt complaint. Now, he didn't have to do so, but he went further by saying, I've not only said that the judgment is clear and unequivocal, but I'm going to order that it be implemented in that way. So he didn't actually clarify what the divorce judgment meant. He said it was clear and unequivocal from the beginning. So when you suggest that he treated this as a motion for clarification, if that's what it was seeking, he denied it. He said, no, it was clear and unequivocal from the beginning, and I'm going to order that it be implemented not later than October 15th, 2018. Both parties shall execute the quadro for $151,805. Is that fair?
Well, I think where the trial transcript shows that the wife testified as to her interpretation as to what that provision meant, specifically that the language of the separation agreement meant that the husband was supposed to transfer 50% of the value at whatever time that was. The husband testified to the contrary. So I think it has to be taken as a motion for clarification, or at least a resolution of the dispute on that issue, whether you call it a clarification or you're just affirming the husband's position. I think that issue was well decided in the previous action.
But to follow up on that, I mean, in a contempt action, the judge, as your brother noted, is deciding, the only thing the judge is obligated to decide is whether or not someone violated a clear and unequivocal order, correct?
Correct.
But part of issue preclusion, one of the requirements is that the issue decided in the prior adjudication was essential to the earlier judgment. If the judge wasn't obligated to do anything other than decide whether or not there was a violation of a clear and unequivocal order, how can we say that his order in the contempt case was essential? The portion that you're talking about. You understand my poorly articulated question?
I think I do, Your Honor. It was essential because the underlying litigation was wholly consumed with the analysis of the number that should be transferred, and whether that is in, I know I'm running low in time, whether that is in I'm sorry, I lost my train of thought.
The issue is whether or not the judge going further, as you said, was essential to that contempt litigation.
May I respond? I'm out of time.
Thank you for asking, and please answer. Yes.
Thank you. I think it was essential to the prior litigation because the contempt had to determine how to resolve the issue of the barred 401k with finality, because otherwise the court is leaving open continued litigation over this issue, which has been in litigation since well prior to 2013.
It would have been helpful, though, if the judge had said in finality that the husband is entitled to the balance of the account.
I agree, Your Honor. It would have been helpful. But
all he did was impose what the original judgment said and left unanswered anything to do with the growth.
Correct, but
other than what you say is implicit in his order.
Yes.
Thank you.
Okay, seeing no further questions, the case is submitted. Thank you both for yours from counsel for the father.
Thank you, Your Honor. May it please the court, my name is Dana Shenevert, and I represent the appellant father, who's asking this court to vacate the decree that terminated his parental rights. Now, envisioning the child's return to father, the judge didn't find his criminal history or even his housing situation determinative. Instead, the trial court based her determination of father's parental unfitness on three factors, primarily. The first factor being a lack of insight into the reasons that the child came into custody in the first place, inappropriate communications with DCF and the foster mother, and then ultimately also an unwillingness to engage in services, namely a psychological evaluation and also a batter's intervention course. However, the trial court's findings underlying her assessment, while supported by the record to a certain degree, do not clearly and convincingly establish father's parental unfitness or current parental unfitness. And I would like to start with father's anger. Now, father...
Before you go forward, You say that the failure to have stable housing was not determinative. Would it be more accurate to say that it was certainly a factor that the judge considered, but perhaps didn't emphasize as much as other factors?
That's fair. That's fair. Because at the end of trial, you know, he had, after 7 years of struggling, after 4 years, let's say 2016, after 3 or 4 years of being DCF involved without getting any help from DCF to get him housing, he finally had secured housing about 2 weeks before trial. And the trial judge found that, you know, although that was a factor, even if he had, even if his housing had been able to be established as long-term, which she was not persuaded, there were other factors. So that's why I say not determinative, definitely in the mix, in the balance. But primarily the court emphasized father's anger, right? Father's anger towards DCF and how it was directed towards the foster parent. But I want this court to think about how reasonable anger might be if DCF removed your child without so much as calling you to let you know. And that is how this case started. This is the groundwork that DCF laid when they were working with my client. They removed his child, called the paternal aunt, even though they knew where father was. And even after the child was removed, father didn't learn of the removal from DCF. He learned of the removal from a family member. So this laid the groundwork for father's conflict-ridden interactions with DCF from the time that the child was brought into custody towards the end. Now, you know, DCF, the social worker, testified, or she did testify that, you know, father had threatened her, father had taken a threatening demeanor with her and other members, other staff at DCF, at the DCF office. But remarkably, during trial, she could not remember any particular incident where she felt threatened or someone else said that they felt threatened. It was very loosey-goosey what she was testifying to. The fact that father admits that his behavior with the DCF social workers and his sister may not have been, you know, appropriate. That's right. Sorry, I was looking for the word. However, the interactions that he was having with DCF and his sister, they did not impact the relationship he had with his child.
Were there any findings about the effect of the anger on the child?
The court did make findings, but I would argue that those findings are not, well, first, they were based on evidence. They were based on what we would argue were improperly denied motions in limine. She relied on the fact that there were reports that this child was experiencing itching symptoms after the visits, and that those symptoms of itching and scratching and having dreams of a purple Grinch were somehow directly tied to some negative interactions with father.
I see that the court made a finding that some of these things occurred around the time of or after visits. I didn't see the court finding that they were due to the visits. So should we give that some weight, or I mean, should we infer that the court found a causal link, or what are we supposed to do with that?
Sure. I think that this court can safely infer that the court did find a causal link, but I would argue that that causal link was not supported by any credible evidence. There was only testimony, or actually it's in the written documentation, that the child was experiencing these things around the times of the visits. I think even it was reported by the foster mother, but there was no expert testimony that would indicate that that the causal link that was created by the judge at the time of trial was in fact the reason that the child was experiencing these things. If we look at the motions in limine that are in the exhibit volume, there are several reasons given why the child could have been suffering from these things, including the trauma caused by the stress of not being able to maintain a consistent relationship with her parents. So what is reflected in the court's findings is an aggressively negative interpretation of the evidence here. That's clearly set forth in the exhibit volume. While there could have been other links that she could have made, she chose the one that was detrimental to father, and that was error. That was an abuse.
Was the father ever assigned as a task in the action plan to attend an anger management class?
He was assigned to attend a batterer's intervention course.
Right, but specifically with regard to anger, there's quite a bit discussed in the DCF and the child's brief about anger management.
Sure. And father testified, and it's noted in the record that he was attending services. He attended services, individual counseling, because he's a recovering alcoholic. So he was already engaged in individual therapy that was targeted towards relapse prevention, and also he said they vetted his anger in those sessions.
I guess my question is, I want to know whether you acknowledge that he was or wasn't assigned a task of attending an anger management class, because the DCF brief says at page 26 that he wasn't participating in important services required of him, such as batterers or anger management treatment, citing findings of fact 95 to 101. But I looked at those findings and I didn't see where he was ever assigned an anger management course. I know there was some discussion by some social worker at a meeting reflected in an exhibit that some consideration was being given to whether he should go to anger management, but I didn't see it as a task on any of the action plans.
And as I'm reviewing the record right now, I don't see it either. It is specific to domestic violence, gaining insight around the impact of domestic violence on the child. But yes, his anger was an issue. It was an issue for DCF, and it was an issue for his sister, but it wasn't an issue for his child, with whom he was able to connect with and have a positive relationship with. And the social worker's own words at exhibit page 92 were that even though he was not in a caretaking role, in the supervised visits, he was able to model empathy and create an environment, I'm just reading here, where the child is able to express herself freely. So to the extent that there was anger or conflict between father and DCF, or father and the foster mother, it did not impact his relationship with the child whatsoever. They had a positive, loving, nurturing relationship. As to the domestic violence allegations that are in the record, those do not clearly and convincingly prove father's unfitness either, because they simply were not only did mother recant those back in 2013, and the social worker testified that she had, and this was documented in the dictation notes that DCF had, that mother had said none of those things that she had said about father were true. And she testified to that she had not read the notes. The ongoing social worker who testified at trial said, "Oh, I didn't read those notes going back to 2013." And despite not having read those notes and relying upon her imperfect information, she tasked father with going to this batterer's prevention course. Now, the trial judge made no findings about that social worker's testimony about what was in the dictation, but yet she seemed to fault him in her finding 101 for refusing to admit that he was a batterer and refusing to attend this course. And father believes that to the extent that this was used as a basis for finding him unfit, it should not be given deference. This findings related to domestic violence should not be given deference. And also, even if, I would say, not that father is admitting that he's a batterer, but even if all those allegations that were proven untrue were true, this was not an ongoing concern at the time of trial. Father had ended his relationship with mother back in 2012 when she falsely accused him of strangling her while she was pregnant. And then he had not been in contact with her since December 2016. So literally for the 3 years preceding trial, he had no contact with mother, and the court so found that. So again, while his anger may not be condoned, it did not inhibit his relationship with his daughter.
The child says in her brief that violence, at least as defined by DCF in its protective intake policy, includes not only physical violence, but a pattern of coercive control. So I see that there are not that many incidents of physical violence. One of them went to trial and resulted in a not guilty from a jury. Another one, the police came and there was an alleged jacket pulling and the police decided there was no assault and battery. But what about the issue of control? Does the DCF family protective intake policy have relevance to whether we should view the father as having a domestic violence problem?
I think yes, all policies here are relevant because they give us insight into what the rule should be, but then we need to take the individual facts of this particular case. It wasn't father who was holding, refusing to leave the relationship with mother and inflicting domestic violence upon her. It was father who left the relationship because of the domestic violence that mother had perpetrated. So he was, and although DCF, I remember at one point said that, they witnessed father's control or trying to assert control, dominate the conversation by talking over. But again, this is not, the argument would be that this is not the type of pattern of control or any control at all that is envisioned by by DCF's articulated policy. Father left the relationship and he did not look back. The relationship had been over for 3 years prior to trial. And lastly, I'd like to talk about the order. Should this court decline to return father's child to him, we need to remand the case, if only to take a look at the order on post-adoption visits. The court erroneously found that an order was not necessary, and an order absolutely is necessary to not only guide this child if the adoption comes to fruition to her new family, but to assure her that she's going to be able to maintain contact with father, who is the only parent with whom the record reflects that she has a meaningful, loving, nurturing relationship. And quite frankly, the only parent who is here trying to maintain a relationship with her. There's no question that father's interactions with this child were positive. There's no question that visits went well. There was no question that he provided for her, changed diapers, provided financial supplies and everything for her before the removal. And that 2 years of visits, he was consistent with them and they went well. He responded to her needs and she responded to him. So there needs to be an order. The order as it currently stands empowers father's estranged sister to be the sole arbiter of whether father is appropriate or not. Meanwhile, there's no argument that the relationship between father and his sister is contentious. So implicitly, the judge found that visitation between parent-child visitation was in this child's best interest. She ordered it on a monthly basis post termination. So in order to make sure that this child's best interests continue to be considered, this court should remand for further proceedings on a visitation plan that truly furthers her best interest. Because currently, I think this court can safely infer that the aunt's focus is not going to be on whether the child should see her father, but whether whether she's liked or respected by father, which is not a consideration that's relevant to the child's best interest. I see my time has expired. So if there are no questions, I'll rest on my brief.
Seeing no further questions, thank you very much. We will now hear from counsel for, I believe, counsel for DCF first, or counsel for the child?
Counsel for DCF.
Counsel for DCF, thank you.
Good afternoon, your honors, and may it please the court. My name is Molly Mahan, and I represent the Department of Children and Families in this matter. The department respectfully requests that this court uphold the decision of the trial court in its entirety. The trial court's conclusion that father is unfit is amply supported by clear and convincing evidence in this matter. Father's unfitness did not consist merely in one factor or one characteristic or one incident. Rather, it was multifaceted. It consisted of, and as is discussed in our briefing, it consisted in his anger issues, in his lack of parenting experience and skills, his inability to formulate a realistic plan for reunification.
So were there findings that the father's anger had caused harm to the child? I didn't find any. Can you point me to any?
Sure, Your Honor. I think the court did find that father had an aggressive and at times violent temper that bore on his current fitness, such as finding conclusion of law 8, and it's discussed in others. The court was concerned about father's temper and his.
Sure, but what we're trying to get at is whether there actually is a nexus. I mean, certainly the court in its conclusions of law said, oh, the father's angry temperament is a factor I'm relying on, but we want to unpack that and see what the findings of fact are that support it.
Sure, Your Honor. I know the court noted that the child had experienced nightmares about father in the conclusion of law. I know you discussed this with counsel for father in her argument. I do think there is a fair connection there. We have in the record, an incident in June, I believe 2017, where father, for instance, had an outburst against a DCF worker supervising a visit while his daughter was in his arms awake. And then a mere 2 months later is when we have the nightmares about father, apparently for the first time beginning. I don't know that I can point you to a direct conclusion of the court that states father's anger. It seems to, it's part of this pattern where it seems as though father has these tendencies that implicate his ability to anticipate and appreciate his daughter's needs and an ability to understand and undertake his parental responsibilities. And the court did find that that father was incapable of fostering or providing a safe and stable environment for his daughter based on this pattern of behavior. And one element of that that featured very prominently in the findings was that father failed to make meaningful progress on the action plan that the department devised for him in order to address his various shortcomings based on the department's firsthand dealings with father and its concerns about his ability to assume full-time care of his daughter. And, this action plan, as consisted of, a batterer's intervention, parenting classes, mental health focused services. And despite the fact that this plan was a condition to father retaining his rights, and he knew this, he met with the department, he, signed the plans, he understood that this was a condition to retaining his rights, and yet he did not engage with this plan meaningfully or make progress on it. And that was a finding of the court as well, that he did not make progress on this plan. And the case law is clear that a parent's failure to abide or complete a plan where tasks are related to, clearly identifiable parental shortcomings are a consideration to parental fitness. And in this case, it really was indicative of unfitness that he didn't engage with this plan, because these tasks were really critical in father's case. They were catered to help him deal with his temper and learn to deal with stress in healthy ways.
Let's just back up a second. And I think you implicitly acknowledged what the father argues in his brief based on the adoption of Yale case, that that the service plan task has to be related to a clearly identified parenting deficiency in order for non-compliance with the task to be the basis of a finding for unfitness. So if you go back to the anger issue, absent a finding that the anger was negatively affecting the child, I understand that it makes the father difficult to deal with for DCF workers, perhaps for the pre-adoptive parent or the foster parent, but how is failure to go get anger management services or related services reasonably required of him without a finding that his anger was negatively affecting his daughter?
Yeah, I think, the department saw in its firsthand experience with father that it was more than merely being difficult to deal with. Anger at the department for taking one's child is totally reasonable and understandable. Father's behavior here seems to have gone a little bit much further than merely being angry at the department in the abstract, and he manifested behaviors that were bordered on the abusive toward the department caseworkers. He was threatening and intimidating and harassing. He harassed them via phone calls. He directed this behavior toward the paternal aunt as well. And father even seemed unable to control his temper with individuals who were not kind of involved in the custody issue. We had the incident of the common purpose individual.
Well, I don't mean to suggest that anger against other people could not ever negatively affect a child. What concerns me is that there's no finding that it did here.
I understand that concern, Your Honor, and I suppose I would point to findings that indicate that father's anger caused disruption during case meetings and resulted in the termination of calls with the child and other sorts of things of that nature that reduced time with the child, and prolonged the impermanency of the child's situation. Father's inability to cooperate and abide these tasks, definitely prolonged, the impermanency of this child's situation.
I don't want to take up all of your time or take away time from my fellow panelists, but I wanted to ask you quickly about domestic violence.
Sure.
There was the January 2nd of 2015 dispute over the restaurant bill, where the mother claimed the father grabbed her jacket. The police came, said this is not an assault and battery. Nothing further came of that. There was the May 31st, 2012 incident before the child was born, as to which the father was found not guilty after jury trial. The 209A was allowed to expire. What recent evidence of domestic violence by the father against the mother was there that would justify saying the father has a domestic violence problem that makes him an unfit parent?
Sure, Your Honor. So one key element, I think, to the domestic violence component is, yes, it is correct that father and mother haven't been involved since 2016. They have not been in contact. This doesn't negate the fact that for the first 3.5 or so years of this child's life, father and mother were in contact. They had a very tumultuous relationship. They fought in the child's presence. The police became involved. The court found that happened, and this had an impact on the child. And what is concerning, that kind of carries this to present, is that father fails to appreciate the impact of this time period on the child. Kind of seems to minimize it just merely because he was found not guilty of assault and battery, when it's clear that there was great instability and tumult in this household at that time. And I think a key thing here is that that is concerning, and the court found it concerning that father didn't appreciate the impact of domestic violence on his child. And then, in DCF's own dealings with father, experienced firsthand his tendency to be volatile and controlling and abusive. So it did continue.
I'm sorry to interrupt you, but your time has expired.
Thank you.
I just want to make sure, Justice Lemire, Justice Sachs, any further questions? Seeing none, thank you very much. And we will hear from counsel for the child, Attorney Solons.
Good morning, may it please the court. I'm Amy Solons and I'm counsel for the child. The child is now 8 years old today, and she has been in care since she was just shy of 4 years old. As you can see from the record, this child is doing very well. This child has had the benefit of being in a stable and continuous kinship placement throughout this case, but she wants that placement to be permanent. This child is asking the court to uphold the judgment of the lower court in its entirety so that she could be adopted by her kinship foster family. On appeal, the father is asking this court to find him fit to be a sole full-time caregiver for this child. It's a role he's never had. His role in this child's life has been fairly limited. There was a very brief...
Can I just back you up for 1 sec? You said it's a role he's never had. Is it up to the father to prove that he has parenting ability, or up to DCF to prove that he doesn't?
It's up to DCF to prove that he doesn't, Your Honor. Where
All
this
right.
father...
So my follow-up there is lack of parenting experience the same as lack of parenting ability?
Well, Your Honor, in this case, one of the issues was the father refused to take a parenting class, and the lower court was concerned about his lack of experience.
Okay, but is the lack of experience the same as lack of ability? There are many, many people in this world who have children for the first time and have no experience with raising children until that moment.
I think with his, there's a couple of issues here, Your Honor. One of them is the lengthy separation he's had from this child, his lack of experience. The court he thought he needed to take some steps for there to be sufficient evidence that he was a capable caregiver. And there is a finding on that point, Your Honor.
What specific parenting skills did he lack?
I think it was, it was several things, Your Honor. It was.
Well, didn't he indicate that he wasn't prepared to even care for her and work at full time he had nobody available to watch her? There were things like that he acknowledged. I think his acknowledgement was he wasn't prepared to take her full time at this point.
Your Honor, he did his own testimony at trial was that he needed services and he needed help to be able to take care of this child. Yet he has always refused those services. By his own admission, he was not ready without any services to take on the care of this child. To get back to what I was saying, his role has been pretty limited. Prior to removal, he saw the child a few times a month, but his parenting experience has primarily been comprised by supervised visitation at the DCF Center for the past 4 years. The child lived with her mother prior to the removal. The mother began to struggle early on with her mental health and substance abuse issues, but the mother did have the wherewithal to recognize she needed some help. And the mother did turn to the paternal aunt, who's now the kinship placement, and she asked for help. And the paternal aunt was willing and able to provide that help and provided consistent care for this child throughout her life. So on December 2nd of 2016, the mother didn't show up to pick up this child at the bus, which was the incident that prompted the removal. But the paternal aunt, a familiar face, was there to pick up pieces, pick up the child, take the child back to her home. And the child has been in the paternal aunt's home ever since. Pretty quickly after removal, the department got visitation up and running with Dad. He was consistent, he was largely appropriate, but those visits were not without issue. He was often preoccupied with his animosity toward the department. He required redirection. He'd become agitated. There was an incidence of yelling and using profanity when he had a child in his arms. And because he was not, oh, I'm sorry, my time is expired.
If you'd like to say something and very briefly to conclude.
Sure. Because he was not willing to engage in any services, and I do list for reference in my brief, I think it's pages 26 and 27, the services DCF requested were broader than domestic violence alone.
Okay, thank you.
And could have addressed some of the issues occurring in his visits. And because he did not do that, DCF had to resort to limiting his contact with the child.
I think we're going to have to leave it there, but let me just check to make sure there aren't any further questions from the panel. Seeing none, thank you. Thank you all for your very
All right, we are live and recording.
Good afternoon. Calling our final case, docket 2020P1076, YRBAS. We'll hear first from counsel for the appellant.
Good afternoon. May it please the court. My name is Taylor Henley and I represent the appellant juvenile. The appellee and the juvenile court judge want this panel to believe that a single, brief, continuous interaction is akin to a 3-act play. But to parse this interaction into a 3-act play requires imposing arbitrary and artificial barriers between otherwise continuous acts. There was not enough time in between these acts for any curtain to fall, literally or metaphorically. So the question for this panel today is this: was this minutes-long continuous interaction a 1-act play or 3? I will first argue today that the juvenile court judge erred in issuing the harassment prevention order against the juvenile because the juvenile's actions do not meet the statutory definition of harassment. I will then argue that the juvenile court judge further erred in failing to account for the mandate of the juvenile court and the adverse consequences for the juvenile in issuing her order.
Let me ask you, well, I think it's a straightforward question, but I think it's an important one. What case provides the best guidance in terms of distinguishing between what constitutes separate acts versus what constitutes continuous conduct under 250 AD?
I think there are 2 cases, Your Honor. The first one is the FK case that's cited in my brief. And in that case, the defendant posted a song with multiple different threatening lyrics onto 2 separate platforms. And he posted those 2 songs in very short, quick succession. And the SJC
it was one song on a larger platform I'm sorry, I don't know the names of the platforms, but it was one song on a wider platform, and then he shared it through his Snapchat with his friends, but they still had to go to the larger platform to get it. So it seemed like he was sharing it with a subset of the group he'd shared it with before.
My understanding, Your Honor, and forgive me if I'm incorrect about this, my understanding is that to share it on Snapchat, he did share it with certain people on Snapchat. He didn't share it with everyone, but he did link it, but it was in quick succession. And admittedly, neither of these cases, the FK case that we're discussing or the Smith case that I'm about to discuss, are exactly on point here. But I do think that they illustrate some of the.
But I guess the point in FK is that the 2, what you're saying were the 2 acts, the sharing of the song on one platform and then another, were acts of a very similar type.
Yes, that is correct.
And it was the same song.
That is correct.
And I guess the question here is, you've got conduct by the juvenile that can be viewed as putting the victim in fear by encouraging her along with the juvenile's friends to walk to the bathroom and get locked in the bathroom. Intimidation, abuse by physical, by an assault and battery. And then intimidation by threatening, among other things, that if the victim ever told the police, she would be stabbed. So it seems to me we've got three, although they occurred in quick succession, we've got three different types of conduct here.
Yes, Your Honor, and I would argue that those three different types of conduct are actually still related to the same one continuous incident. And so while the type of conduct is certainly relevant to whether the conduct is willful and malicious, and we would certainly concede here that this one act that we would argue is one act is willful and malicious and constitutes the one act, I don't think it's relevant to whether there were three separate acts. I think that, and in this here, I think it's important to look to at a couple of unpublished cases that I provided to this court in my 16L letter, because although they're unpublished, I think they are persuasive here and they are grappling with some of the similar issues. And in one of those cases, and that's the AG case, the defendant left the plaintiff a harassing voicemail and then showed up at her place of work 45 minutes later. And the court had said that those were two separate instances because they were, and I'm quoting here, more distinct in time and in subject matter than in FK or in the Smith case, which was the case in which the defendant drove by the plaintiff's house 3 times in short succession. And the court found that that was one continuous incident. And I think that's an important distinction here too, because the timing here is much shorter than in the 45 minutes in the AG case. The plaintiff testified that she was in the bathroom for 10 minutes. She also testified that the bathroom was right near where the juvenile first approached her. And moreover, I think that the subject matter is also the same here in contrast to the AG
So
case.
what is the timing from the amount of time elapsed from the very first act until the third act had been completed? Yeah, assuming there are 3 acts. I understand your argument.
Of course, Your Honor. The judge did not make any findings as to the exact specific timing. So the best we can do is look to the record. The plaintiff testified that she was in the bathroom for 10 minutes. And so, and if we break up the acts according to what the trial court did, she also testified that the bathroom was, I think, right around the corner, were her words, from where she was first approached.
So are you saying an outer limit of maybe 15 minutes total? I mean, do you have a ballpark?
Yes, I apologize. I didn't mean to interrupt you.
No, go ahead. You're not.
I used approximately 10 minutes in my brief. And the reason why I did that is because if she was in the bathroom for 10 minutes until someone came and got them out, that it all happened very quickly. But I think perhaps we could do an estimation of 15 as an outer limit. And I think that the argument still stands here that this was one continuous incident. I also do want to point the court's attention to a similar, also unpublished case, but I think persuasive here, the SM case that I cited in my 16L letter. And in that case, the court specifically found that harassing conduct that occurs within a very short period of time is considered to be one continuous act, and it cites the Smith case to justify that.
Just on that point, so the 250-80 was enacted with reference to the criminal harassment statute. Obviously, it provides a different remedy. It provides a different definition of harassment. It can be initiated civilly rather than criminally, but the definition of criminal harassment requires that the conduct, this is chapter 265, section 43A. It requires that the conduct or series of acts occur, and now I'm quoting, over a period of time. Whereas when the legislature enacted 250-80, they left that phrase over a period of time out of the definition of harassment. So what should we make of that?
Your Honor, I think that although they did leave that definition out, I would also point to a couple of other parts of the legislative scheme. The first is that this legislation was enacted to for the purpose of providing protection that is unavailable under the 209A restraining order scheme. And so that, for example, the DeMaio case I cite in my brief goes into that in detail. But it, and that shows that the purpose of the statute is to provide relief for stalking and criminal harassment and sexual assault, which is not relevant here.
But a single incident can be enough under the 209A statute.
Exactly.
So when we talk about 250-80 providing relief that's unavailable, we're not talking about requiring less conduct. The real difference is who the relief is available against. It doesn't have to be a family or household member or former significant other, people in those categories.
Yes, that is correct, Your Honor. But I do think it's important that they added in stalking and that they added in the language of 3 or more acts, which is not a part of the 209A statute. because stalking is not something that you can do in 10 or 15 minutes. It's over a larger period of time. And a lot of the cases that have upheld orders under the 258E statutory scheme are much longer. For example, the JC case is 15 months, excuse me. The AT case, which is one of the shorter cases, upholds a 2-month order on 3 separate days.
But there's basically no time requirement in 258E. Would you agree with that? I mean, there is one in the criminal harassment statute. There is not one in 258E.
I would agree that there's no explicit time requirement. I would say that the cases have found that there needs to be 3 separate acts, and that given that, and that one continuous act cannot be broken up into its constituent parts. And given that, I think that the legislature would not have written in 3 separate acts if one continuous incident.
So that sort of begs the question, what is a continuous act? You know, in the Smith case, you had driving by the house, I guess with a few turnarounds, but those didn't break the continuity of the driving. In FK, you had posting the song to one platform and then to a subset of people who had access to that platform. Here, and I come back to what I asked a few minutes ago, you have putting the victim in fear outside of the bathroom. You have engaging in abuse by physically assaulting the victim inside the bathroom. And then you have intimidation by telling the victim that if she tells the police or anyone, she'll be stabbed. I don't see that that's a continuous, one continuous act. I see some pretty straightforward distinctions between the portions of this this incident.
I would say to 2 things, Your Honor. First is that we know that the period of time, as I mentioned, and the subject matter are significant. And I think both point to one continuous incident here, because although there were different conduct, as in a threat versus a punch, for example, it was all around the same fight. It was all in the same general location in this mall. It involved all 3 of the same, or 4, excuse me, I believe, the same girls, the same teenagers. And there was no sort of breaking point of anything other than what the continuous threat, forcing into the bathroom, then fighting in the bathroom, and then threatening on the way out of the bathroom. There was nothing to sort of break this up. Unlike in the AG case where the defendant there left a phone call and then had to drive 45 minutes to be able to get to the house.
So your focus is on the temporal, the time. In other words, if 15 different events or 15 separate incidences of threatening, assaulting, intimidating occurred within 10 minutes, that it doesn't matter how many times they either slapped her or punched her or kicked her or threatened her. It's not the number of things they do to her in that time frame. It's the fact that it's a consolidated time frame without a break.
Yes, that is correct, and as well as it's around the same subject matter. So to use your example, if and I'm not sure how in 15 minutes or so or 10 minutes there could be a different subject matter, but if there were some sort of break in between to change the subject matter, I think that would be significant. I would also acknowledge that certainly while this conduct is certainly inappropriate, there are other ways to deal with this conduct than through the 258E harassment prevention order scheme.
Well, let me ask you about that. There are many references in the record, and I think in the transcript, of a criminal case being brought. Was a criminal case brought against the juvenile?
Yes, there was, Your Honor.
Is that case pending, or has it been resolved?
It is still pending, Your Honor, and forgive me for going outside the record, but it is currently being scheduled for trial on the next date.
All right, so that, I think that's as far as the record on that. Let's just go with that question. Okay, thank you. But you could continue your answer with respect to what other avenues of relief there could be.
Yes, thank you, Your Honor. And so that dovetails right into my argument about the other avenues of relief. This is inappropriate conduct, to be sure, but there is an entire delinquency scheme for this kind of conduct. In that, the judge could order a stay-away order as a condition of bail under Section 58, for example. If the juvenile was not arraigned, that could still be
That's up to the Commonwealth to bring that case, and the relief is available if the Commonwealth seeks it. The victim here would have no standing to pursue that sort of relief.
No, Your Honor.
So why isn't it consistent with the larger purpose of 258E, which is to provide some avenue for victims privately to seek relief, even if the district attorney doesn't believe it rises to that level of criminal or delinquent conduct.
I would point again to the requirement that it had 3 separate acts, Your Honor, and that the legislature has other statutes to deal with the fight. I think if this conduct were to be allowed as a basis of a harassment prevention order, then any fight, even something as short as 30 seconds, as long as it had a punch, a kick, or a threat, could be grounds for a harassment prevention order.
Well, that actually raises maybe an overarching question. Can you give us some help by pointing to the purposes of Chapter 250 AD or anything in the legislative history that helps us decide when a course of conduct over a short period of time can be divided up into different components? How would it serve the purposes of 250 AD to rule in your client's favor, or frustrate the purposes of 250 AD to rule in the appellee's favor?
Your Honor, to be quite frank, I'm not aware of any cases or even any legislative history that specifically gives a line of what it constitutes 3 separate acts.
Or suggests a policy from which we can derive a line somehow. What are we trying to do by looking at whether a course of conduct can be considered 3 separate acts, other than satisfy the language of the statute? Why is that language important?
I think I would point to then the cases such as the AR case, the Gassman case, and the DeMaio case, which talk at length about the harassment prevention statute and the judge's natural inclination to want parties to stay away from each other when there is bad conduct, and how even though that's a natural inclination, the cases are clear that this is not sufficient to justify an order in absence of 3 acts. I apologize. I realize my time is spoken.
You can complete. Please answer the question.
Thank you. And that the reason for that is because the collateral consequences for a defendant, or particularly for a juvenile, are significant here, ranging from criminal liability if it's violated, to appearing on the juvenile's criminal activity, court activity record information, to access to communities, to school, to other everyday activities. This is particularly severe for juveniles, and so I would point to those cases.
Any further questions from the panel? Seeing none, thank you very much for your argument, and we will hear from Attorney Guyman on behalf of the appellee.
Thank you, Your Honor, and may it please the court. I do want to hone in a bit on some of the items that were discussed with Attorney Henley, specifically the lack of any timing requirement in the statute. I do think that some of the cases Attorney Henley brings the court's attention to are helpful, but not necessarily in the way that she suggests. I think the AG versus KO unpublished case that Attorney Henley referenced with regards to a defendant in that case who left a voicemail and then showed up at a nursing home 45 minutes later actually doesn't suggest that there's a timing requirement. I think it suggests, and I would suggest to the court, that there is no bright line test. There is no bright line test on time. It's not in the statute. There is no case law that provides any sort of a bright line test. It's not 45 minutes. It's not 15, nor is it 3 days. It is left, I think, purposefully by the legislature for the courts to decide if there are 3 separate representative acts without any reference to time. I think what may be more appropriate, if I may, is the intent of the defendants and the way in which the plaintiff was made to feel. In other words, the statute does list requisite.
Just backing up for a second, what is the purpose of requiring that there be 3 acts rather than 1 in order for an order to issue?
I think, Your Honor, it demonstrates the legislature's intent that it not be easily available to a plaintiff, to open a civil action and to get the extraordinary relief of a 250 AD harassment order without evidence that it's a continuing episode, that it's not just one isolated example, that it's something that is broader, but not
Right.
necessarily.
So why don't 3 acts within a 10 to 15 minute period constitute an isolated example?
Because, Your Honor, I think if you look at this case, for instance, where a plaintiff was made to feel fear, was abused, and was intimidated, threatened in one course of action, it's not necessarily dispositive whether that happened in 15 minutes or in 15 days. Those 3 requisite acts. If, for example, to use the Smith case, the Smith versus Masterless case that was referenced earlier, there was one incident of fear in which a defendant drove by a plaintiff's home a number of times and caused one of those, intentionally and maliciously caused one of those emotions, fear. If the defendant had then gotten out of the car and punched the plaintiff, and then as the plaintiff lay there on the ground said, "If you tell anybody, I'm going to stab you," I think arguably those 3 acts would have occurred even though they were in quick succession. And that, my argument is, Your Honor, that that's what happened here. That though it happened in admittedly a short time frame, those 3 acts did occur. I think.
So, counsel, if this same event took place and no words were spoken, and there were just, say, 3 acts of physical assault, let's just say a push, a slap, and a kick, then that wouldn't be enough under your theory, correct?
Correct, Your Honor. That would not be enough. That
So
would
the
be
same amount of time, the same people involved, the same location, but it's because they, in addition to having a physical altercation, there were words exchanged that constituted either threats or intimidation.
Yes, Your Honor. I do think that because the plaintiff, the victim in this case, was put in fear before they were ever inside that bathroom. When she was met in the hall of that mall, and she was essentially told that they wanted to fight her, she was put in fear. That alone is one act. That's one act of making somebody intentionally feel fearful for their lives, their health. They then move into the bathroom where, and this is all undisputed, these girls then kick, punch, shove, lift the shirt of this girl, abuse her. It's violent. There's blood. That's all, again, undisputed. And then the third act is after the fight is done, the girl is laying there bloodied. The security guards are leading this girl out of the room. The fight is over. That's undisputed. And the defendant, of her own volition, turns to the victim and threatens her and says, "You're going to get stabbed if you tell anybody about this." And apparently the victim's younger sister was threatened as well. Those are 3 requisite acts, admittedly in quick succession. But unlike the other cases that that Attorney Henley cites to, there are 3 requisite acts.
Well, let me follow up. Since Justice Lemire stole my question, let me follow up with by expanding on it with a hypothetical. So here's your hypothetical. A and B are neighbors. There's, let's say, some history between them. A approaches B in front of his house, and A starts yelling at B, and A punches B in the face. B walks up the stairs onto his porch. A walks up on the steps, yells at B, and punches B a second time. A walks down, leaves the porch, yells again at B, and walks back up a third time and punches the person again in the face. The whole thing takes 4 minutes. Is there enough there for B to get a 258E order?
I don't believe so, Your Honor. I think what I would suggest you've displayed is a case where there was arguably an instance of fear, of intentionally putting the neighbor in fear. and then there's a second act of abuse. I think that is a good example of a continuous act of abuse.
Let me change the hypothetical slightly. A walks over to B in front of the house. A says, I don't like you. I'm going to get you. I've had it with you. B walks away, goes upstairs onto the porch. A follows B up, yells, and this time strikes B. A walks down after doing so, leaves the porch, turns around and says, if you tell anyone, I'm going to get you. Entire episode takes 2 minutes. Is B entitled to a 250-80 or not?
I think in that instance, yes, Your Honor. I think there would be 3 requisite acts, again, regardless of time, because neither the statute nor any case law provides a bright line test on time. Admittedly, it all happens very quickly, but you do have 3 requisite acts, intentional and malicious. The first, putting B in fear for his life or his welfare. B, the instance of abuse, as you've just described it, on the porch. And C, the very clear threat or intimidation that if B tells anybody, that it could happen again.
My concern is trying to come up with a limit. I understand that these are fact-specific cases, but I'm trying to come up with a limiting principle of some sort. Your principle seems to be just different types of conduct, and I don't know if that is an appropriate basis on which to distinguish the 2 hypotheticals. I truly don't know the answer to that.
Unlike three acts of the same conduct. So, but there's still 3 acts. Like
why should the difference be based upon whether it's a punch or a threat?
I think, Your Honor, if I may, if you were to take your example and space it all out now, okay? Now let's say A says to B as his neighbor, I don't like you, I'm gonna get you. A day passes. B's on his porch. A comes onto the porch, punches him in the face, leaves. And a day later, B is on his porch again. A comes by, walks by and says, hey, if you tell anybody what happened yesterday, I'm going to get you. And if you would look at those, even now looking at them and saying, well, they're a day apart, if you would look at those as 3 requisite acts that entitle B to a harassment order under 258E, I would respectfully suggest that it doesn't matter whether it all happened in 5 minutes or 2 minutes or 3 days apart. Those acts are
maybe, but if, go ahead, Judge Lemire.
Well, I was going to say, but you said if there were 3 physical acts, they wouldn't. But taking your same example, if they went up and slapped her one day and then came back the next day and slapped her again, and then on the 3rd day slapped her a 3rd time, there would be 3 acts. But if they slapped her 3 times in one event, there wouldn't be 3 acts.
I think it would be much harder, given that example. I think it would be very difficult if they were 3 slaps in quick succession to say that those are separate acts, that they are separate acts. Intent is sort of, I think, the key here, because when somebody slaps somebody 3 times in quick succession, it's really based on the same intent at that point in time to put somebody or to abuse somebody. Somebody is sort of acting almost unthinking. They're almost unthinking at that point when they slap somebody in 3 times in quick succession. When they come back day after day and do it, well, each time there's a separate intent. And I think intent is the key, Your Honor. I think here there was an intent to put this girl in fear, and they succeeded. And there was an intent to abuse this girl in the bathroom, and they succeeded. And there was an intent to intimidate this girl after the fact, and they succeeded.
So you're suggesting the acts have to have a separate intent?
I do, Your Honor, yes.
Or it could be the same intent on separate occasions.
I suppose that's right too, yes. But here it seems very clear to me, and I would suggest to the court that there were 3 distinctive acts with intent, separate intent to cause separate emotions or separate acts to the plaintiff. I think the timing is a red herring. I think that the statute is silent on the time. There's no case that Attorney Henley has presented that clears up for the court any sort of bright line test on time. And I would ask the court to disregard the time in this particular case.
If the panel has any further questions? Seeing none, thank you both for your excellent arguments. Both clients received excellent representation on this case in both the briefing and argument in the cases submitted. Thank you.